Good morning, everyone. Hope everyone's doing well today.
Okay.
Hi, Ms. Greenhouse. Good to see you.
Good morning, Judge Moore. Thank you. You too.
Thank
Good
you.
morning, Judge.
Good morning.
Good morning, Judge.
Morning.
Let's see. Courtroom 2, whenever you're ready.
Yes, we're ready. Good morning, Judge.
Good morning. How's everyone today?
Pretty good. Thank you for asking.
Who do we have?
This is going to be position 1, Mr. Abdullah Harris.
Okay. And who's representing Mr. Abdullah Harris this morning?
I am Judge.
Okay, thank you, Mr. Finley. Good morning. And this is going to be a negotiated plea, Mr. Finley? Good
That's
morning.
correct, Judge.
Okay, thank you. Good morning, Mr. Abdullah Harris. I'm Judge Eric Moore. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes,
Is that a yes?
yes, sir.
Okay, thank you. Can you raise your right hand for me, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Good morning, Ms. King. Is this your case?
It is, Your Honor. Good morning.
Good morning. You can proceed.
Thank you, Your Honor. Had this case gone to trial, the state would have shown that on June 11th of 2022, Officer Leonard was dispatched to the Chevron gas station located at 507 Joseph E. Lowry Boulevard. He was dispatched to a criminal trespass call, Your Honor. When he arrived, he actually observed the defendant pacing in a parking lot near a trash can. When he made contact with the defendant, he asked him to give his ID, which he did. And when they checked his GCIC, they determined that he was wanted out of Florida on an FTA. They also confirmed with the clerk at the store that he had been criminally trespassed on May 26th of 2022 after shoplifting at that same location. At that time, he was taken into custody. The negotiated terms are as follows. For criminal trespass, 12 months to serve 12 days with credit for time served 12 days with the balance probated. Stay away from the incident location, 507 Joseph E. Lowry Boulevard Southwest, and alcohol drug evaluation and treatment. Would the defense stipulate to a factual basis, venue, and ID for the purpose of the plea?
We do.
Okay, Mr. Finley?
Yes, Judge. Excuse me. Yes, Judge. That is our understanding of the offer, of which we do agree. We would just ask, Judge, that once he does complete the ADET, that the balance of his probation could be terminated. But if not inclined, then non-reporting judge, as that's the only condition on here.
No objection from the state, Your Honor.
Okay. Mr. Abdullah Harris, it's my understanding that in case 22 CR 003727E, you wish to plead guilty to criminal trespass and possession and use of a drug-related object. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury and that by pleading guilty, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your plea as negotiated. Mr. Abdullah Harris, I'm going to waive the fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, the probation will terminate, okay?
Yes, sir.
All right, good luck to you, sir.
Thank you, sir.
You're welcome.
Next, we have position number 2, Mr. Joseph Allen.
And who's representing Mr. Allen? Good morning, Ms. Watson Cafe. How are you?
Good, Your Honor. How are you?
Good. What are we going to do with Mr. Allen today?
I'm sorry, with which client?
This is position number 2, Joseph Allen.
I thought I was only on Hoosier and Williams.
Okay, I have an indication that we need a conflict attorney for position number 2.
Oh, so I'd be appointed now. Okay. I don't know. I would imagine it would be, I don't know. I guess,
You need to talk to him?
not, yeah.
Okay. All right, so courtroom 2, can we go to someone else and have Miss Watson Cafe call Mr. Allen if that's possible?
Not a problem.
Okay, very good.
Ellen, you can have a seat over there by the chair.
What are your other cases, Miss Watson Cafe? Do you have the position?
I don't have a position. It's
Okay.
Devontae Hoosier, Hoosier, and then Don Travius Williams.
Okay, thank you.
We can do position 24, Mr. Tucker. Come on, Mr. Tucker.
Good morning, Miss Helen. How are you?
I'm doing good, Judge. How are you doing?
Good, thank you. So, Mr. Tucker, we are going to arraign him, and you'd like a bond hearing?
Yes, Your Honor.
Okay. Good morning, Mr. Tucker. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Tucker, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Mr. Tucker, you've been charged in case 22 CR 003830Y with disorderly conduct and simple battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Your Honor.
How do you plead to these charges, Mr. Tucker, guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. I have his bond that was set on June 15th of this year of $2,500 cash bond for each charge, making it a total of a $5,000 cash bond. Who do we have from pretrial this morning? Let's see, Ms. Harrison. Good morning. Seems like we were just here.
Yeah. I'm showing 2 cycles, but he has an open case. 22 SC 182204 for aggravated assault, family violence, 2 counts and a battery family violence misdemeanor.
What year was that? 2000?
February of this year.
Okay. And is that it?
Yes, Judge.
Who's presenting for the state?
My ex-wife, we lived together at the same address, and even my ex-wife,
Your Honor, are we on position 24?
Yes, we are.
Okay. And so I'm sorry, can you ask the question one more time?
That's no problem. And is the last name Bacchus?
Yes, sir.
Okay, good morning, Ms. Bacchus. I think this is the first time that you've appeared before me, so welcome.
Yes, sir. Happy to be before you.
Okay, very good. So given that it's a bond hearing, I just need to know what the state's position is and some of the facts of the case.
Okay, Your Honor. The facts of the case are as such. Officers received a dispute call. The caller said that there was a man beating up on a woman with an afro, and the caller gave this description of what the suspect was wearing. Officers canvassed the area and located the 2 individuals matching the description. It was the defendant and the victim, LaPrincia Harris. LaPrincia is spelled LaPrincia, last name Harris, common spelling. The caller stated she saw the defendant chasing the victim on foot, grab the victim by the back of the shirt and drag her down the street. The victim said that the defendant was hitting her and she was yelling for him to stop, but that he wouldn't. And she said he was, quote, beating her ass, unquote, and said that she hated the fact that this happened in front of an elderly home. While in custody, in the back of the police car, the victim or the defendant did say to the police officers that he tried to grab the victim's bag so that he could get his belongings. The state's position as far as the bond, Your Honor, we think that the bond should stay where it is there for each count. It's a $2,500 surety bond. While this defendant does not have an extensive criminal history, The 2 cycles he has are both in 2022, and they're about 4 months apart, and both for violent offenses. So this defendant is obviously unfazed by the violent nature of these incidents, unfazed by interaction with the police and court instruction. He's clearly a danger to Ms. Harris, and doesn't heed, like I said, the court's instructions. So it's likely that he'll reoffend with this particular victim. And for that reason, we feel as though the bond should stay where it is, and nothing further from the state, Your Honor.
Do you know whether or not it's the same victim in the February 2022 case as the present case?
I do not have that information. Well, just 1 second, Your Honor.
Okay. And as you look for that, Ms. Helen?
Yes, Your Honor. And I just want to take a moment. I just want to ask if Evelyn Ware is in the courtroom physically. That is Mr. Tucker's grandmother. And I do believe she wants to speak on behalf of Mr. Tucker.
Are you Ms. Ware? Yes, Ms. Ware is in the court with us.
And Your Honor, I just asked for a short opportunity for Ms. Ware to speak on behalf of Mr. Tucker.
Okay, that's fine, Ms. Helen. Come on up, Ms. Ware. If you'll come to the microphone over here. Yes, just over to the microphone so that you can be heard. Good morning, ma'am. Right here.
Good morning.
Good morning. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can put your hand down. Tell me your full name, ma'am.
Evelyn D. Ware.
Okay, what would you like to tell the court, Ms. Ware?
I just want to tell the court, Jeremiah, doing this, I put it in, I hate it. He's not a bad child, but we've been going through a lot with his mother here for the last 2 years. And he been kind of stressed out along with me. And in fact, I got me some counseling. I got a meeting today, and I tried to get him to go. But he always worried about his mother. And I think this last time when she went in and they amputated her legs and her feet, I think this kind of pushed them to the limit, because he did me the same way. And I'm just hoping that he get his get back to counsel. I had him going to counsel, but he stayed with fine. But I think this did it to him because he did it to me. And I just hope that he can overcome, because he was the overseer of his mother ever since he was about 15. Because they lived together. And she go to dialysis. She went to COVID. She stayed in COVID about 3 months. And this last year, I think they pushed him to the limit and me too. But, and I've been able to see about him and her both. She had a rehabilitation place. You know. We just had a hard time this year for the last year and a half.
Does Mr. Tucker live with you?
He do now, since because his mama been in and out with me. You know, because he got what he couldn't see about her because she had to go to dialysis. So he stayed with me half the time. She stayed with me most of the time. So he in and out helping me with her.
Okay. And what's the mother's name?
Kiwanis Ware. And she out at the upper rehabilitation center on Riverdale Road. She went out there after they amputated her leg this last time, and that kind of did it for him and me too.
Okay.
And I hope to give him a chance. I told him to go to the council. Like I found him, I went to Grace, they put me on council. And the lady gave me a place for him to go, kept saying right on time, but I knew it wasn't. And if he just allowed him to go to this council and give some help, I don't think he'll get anything like this, because he's really not no bad child. He's really not. He's not no disrespectful child. He got himself caught up in something this time.
Thank you, ma'am.
Thank you, Linda. Voice my opinion.
All right. Hold on 1 second. Any questions? Any other questions for Ms. Ware? Okay. If not, thank you, ma'am.
Okay.
Your Honor, I was able to find that information. It was the same victim. It was earlier in 2022. It was an ag assault. It was a felony ag assault against the same victim. I do have that felony case number if you want it. And there was also a no contact order in place already when this happened.
Okay, thank you. That's what I needed to know. Ms. Helen?
Yes, Your Honor. After speaking with Mr. Tucker, and then also contacting his grandmother, Evelyn Ware. This is not a violent offender or a consistently historical violent offender. We are asking for a signature bond because Mr. Tucker has no financial way of bonding himself out. Even his grandmother and his mother are not financially able to bond Mr. Tucker out because it is a $5,000 cash bond. We are asking for that signature bond, again, because of his financial situation. And Judge, going to the Ayala factors, Mr. Tucker will come to all of his court dates. Again, he does not have a history of not reporting to any court dates or not appearing. He is not a threat to the victim. I have spoken with Mr. Tucker. I also spoke to Ms. Harris, who is the alleged victim in this case. Neither party knew that there was a no contact since February, neither party. I have spoken to Mr. Tucker. There is no contact with Ms. Harris. I went down and spoke to him at the Rice Street Jail. There is a felony bond order. There is no contact with Ms. Harris. What I am asking, Judge, is that he is a young 22-year-old man. I want to give him an opportunity to be able to bond out and get out and fight this case, which he is pleading not guilty to, Your Honor, from the street instead of Rice Street, Your Honor. Also a threat to the community. He does not have a history to be a threat to anyone else in the community, Judge. And again, will he reoffend? He does not have a history to say he's going to reoffend, even against this victim. Judge, I understand that there's that previous incident. It's still open. That's still an open case. He has not been found guilty of any other charges violent against Ms. Harris. We are asking for that signature bond. And Judge, if you feel that signature bond is, he isn't eligible for that, we are asking for a bond modification from cash to surety, Judge, for a $500 surety for the disorderly and a $1,000 battery family violence surety bond for that charge, Your Honor.
Your Honor, if I may, for the first felony case that we discussed, he already paid, this defendant already paid a $20,000 cash bond. So as you can see, he's willing to pay a bond and then still reoffend. And I can understand what the argument that PD Helen is making as far as him not having finances and that he doesn't have an extensive history. However, he obviously is not indigent. He has the means to pay the first bond. And second, with this particular defendant, the fact that he has reoffended twice within a short period of time, within a 4-month span, he obviously will reoffend. And I'm sorry, that was a $20,000 surety bond.
Yes, Your Honor. I was going to say Mr. Tucker did not pay $20,000 cash.
My apologies. It was definitely surety.
And at this point, he's still an indigent client, has no income, is not currently working, and is incarcerated, and has a 5-month-old boy on the way, which he would like to be a provider in his life financially for, Your Honor. So again, we are asking for that signature bond. If not the signature bond, Judge, we are asking for that bond modification from cash to surety, Judge, of $1,500.
Okay. Ms. Helen, you know that one of my biggest pet peeves is when someone goes back and violates a previous order where there's a no contact and then there's another allegation of similar behavior. So I can't reward him by giving him a signature bond. What I am going to do is I'm going to convert the cash bond into a surety bond on each count. So it's going to be a $2,500 surety bond for each count, which makes it a total of a $5,000 surety bond. And if the previous judge did not make it perfectly clear, there can be, Mr. Tucker, no contact with Ms. Harris. And when I say no contact, I mean absolutely no contact. No phone contact, no email contact, no social media contact, no personal contact, no contact whatsoever. If that's the case, then you're going to be in violation of not only this order, but of the previous order. You understand that, Mr. Tucker?
Yes, sir.
All right. And no drugs, alcohol, weapons while out on bond. There was not a request for stay away on the previous order. Ms. Bacchus, do you know if there's, and I take it that that there was, that they don't live together, or given that there's no stay away on the previous order?
And business.
I do not see that they reside together. PD Helen, do you have anything different on that?
They do not reside together.
don't
Ms.
believe
Ware just testified that Mr. Tucker lives with her, and I do believe I have her address as his residential address as well. I do not believe Ms. Harris and Mr. Tucker reside together.
Well, Your Honor, what I will say is this, that because there is obviously violence and contention between these two, the defendant and the victim, it doesn't hurt to add the stay away from her location, to stay away from her address. But that should be a part of the no contact, really.
Right, that's, but I don't mind adding that stay away from wherever her residence is. All right, anything further on Mr. Tucker this morning?
No, Your Honor.
All right, good luck to you, sir. Thank you. Who do we have next?
Position 12, Mr. Johnson.
Number 3, Mr. Arnold.
Oh,
My associate was done.
Let's see, did someone speak with Mr. Johnson? I have that he was outsourced to Cobb.
Judge, I do need to speak with him before he was in Cobb when I went to Fulton.
said that,
Okay. So,
And
let's
Judge,
see.
we can do position 16 through 28 if,
Yeah, I can give him a quick call.
Okay,
Oh, let's do number 3 real quick.
number 3.
Number 3 real quick.
okay, all right. So before you speak with Mr. Finley, let's do Mr. Arnold.
Yeah, and Mr. Arnold is just going to be an arraignment judge, and no need to address bond.
Okay. And is he at 7 South?
Yes, sir.
Okay. Good morning, Mr. Arnold. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Can you hear me, Mr. Arnold?
Yes.
Okay. Do you agree to have your case heard by video? Yes. All right. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? All right, you can put your hand down. Thank you, sir. Mr. Arnold, you've been charged in case 22 CR 003832C with simple battery. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finland?
I do, Judge.
How do you plead, Mr. Arnold? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir. Okay, who do we have next?
position 27, Mr. Williams.
And can we get Mr. Finley to speak with,
Yeah, I'm going to give a call right now, Judge.
okay, thank you.
Lowercase j.
Good morning, Your Honor.
Good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Yes, Your Honor.
Okay, thank you. Can you raise your right hand for me, Mr. Williams? Do you swear affirm the testimony that you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down, Mr. Williams. Given that this is a non-negotiated plea, Ms. Harrison, can you give me the history, please?
I thank you very much.
Williams, Tyrone, Judge.
It's position number 27, Tyrone Williams.
Yes, I'm listening. I'm speaking with him now. What would you like for me to relate to him? No, she asked if her other clients, Ms. Watson asked if her other clients are here. Who's the other client?
53 Cycles.
Williams?
Last arrest
Williams.
was May of this year for possession and use of drug-related objects. No disposition listed in that arrest. One moment.
I'm
He
sorry, Ms.
also
Harris.
has a history in New Jersey. He has a 2019 arrest by MARTA Police Department for a CWAC charge, no disposition listed. It was a misdemeanor. A 2019 criminal trespass, Fulton County. That was a conviction. 2018, another criminal trespass, also on Fulton County. A 2018 disorderly conduct, Fulton County. Two failure to appear within the past 10 years. He has a 2019 willful obstruction of law enforcement officers, also out of Fulton County. A 2019 criminal trespass. A 2016 probation violation. A 2015 simple battery, 2 counts, misdemeanor convictions. A 2015 reckless conduct. Nothing further, Judge.
Thank you. Let's see, Ms. Bacchus, is this your case?
This is my case, Your Honor.
Okay.
So, Your Honor, the facts of this case are that the officers were patrolling the North Avenue MARTA station when they observed the defendant bypassing the station, jumping over without paying the fare. When they asked if he had a Breeze card, he produced 2, but both had a 0 balance. So the officers detained the defendant at the time and ran the information, which they discovered he already had 2 active MARTA suspensions, which ran from June 3rd of 2022 to July 4th, 2022. The defendant was then arrested and given a suspension extension. Your Honor, the reason we offered to Mr. Williams 12 months, 90 days, credit for time served, 12 days, balance suspended, and a stay away from the incident location, and no alcohol, drugs, or weapons. Really, our reasoning behind this is that this defendant has an extensive history of 53 cycles, as pretrial just said, in addition to the New Jersey history. More specifically, in the last 5 years, he has 8 cycles, of which 4 were criminal trespass charges, 3 of which resulted in MARTA suspensions. He refuses to abide by the MARTA suspensions. He refuses to obey the court's instructions. And because of his nonchalant attitude towards reoffense, the state feels as though jail time is appropriate. Nothing further from the state, Your Honor.
Yes, Your Honor. As you've seen, we've had many fare evasions and criminal trespasses in this court. I think 90 days to serve is egregious for Mr. Williams, considering there was no violence, there were no weapons, there were no threats. He tried to present 2 Breeze cards. Unfortunately, they were 0 balance, Judge. So he wants to, I'm asking for time served, balance suspended as a recommendation. He spent 15 days on this criminal trespass. Judge, we are asking for that to be time served, again, for a year of probation. He is not working at the moment, so a year of probation, $30 a month for a MARTA violation, Judge, I think is egregious. So I'm asking for time served, balance suspended based on or to adhere to any MARTA suspensions. Again, he uses MARTA because he needs to use it to get to work, Judge. So I don't want him banned from MARTA. We are not asking for him to be banned from MARTA. We're asking that he abide by all suspensions. And when I spoke to him, he was not aware of those suspensions. And just now he was aware that it's been extended. We'd actually like to know what that extension is so that he can abide by it.
Your Honor, the extension, as I said, is through 8/4. What I will say is that the defendant's history, while not paying the fare, the MARTA fare, may not be egregious and violent, his history is extensive. And he is, as I said before, he doesn't abide by, and if he's using the MARTA to get to work, then he should be paying the $250. He presented those 2 Breeze cards, but he knew that they did not have money on them, which is why he jumped over, and it was intentional. And so I would argue that jail time is appropriate because he does not heed to other conditions.
And yes, Judge, he spent 15 days of that jail time. We're asking for that to be considered time served with the balance suspended, Your Honor.
Balance, we are asking for balance to be suspended and no probation fees, which is why, again, the jail time is appropriate.
Okay, let's see. Miss Helen, does he have a place to live?
Judge, when that incident happened, he did not. He has given me since then an address of 238 Elm Street, Northwest Atlanta, apartment 6, Georgia 30314. I also have a working phone number as well.
Okay. What I'm inclined to do, Ms. Helen, is that I'm inclined to give him time served, but at the same time, I'm also inclined to make sure that he does 20 hours of community service in this regard. I'll waive the fees for him while he's on and have him be on probation. I'll waive the fees for him while he's on probation. And when he completes the 20 hours, then it'll go to a non-reporting. So he'll still be on probation, but non-reporting.
And Mr. Williams, do you understand that, Judge? I just want to make sure he's being offered time served with balance probated, 20 hours of community service. Once he completes that community service, it will go non-reporting?
Yes.
Yes, ma'am. I understand, ma'am.
I'm sorry, could you just say it a little?
Your Honor and Ms. Helen, I understand the condition.
Okay. I think he said he understands, Ms. Helen.
Yes, Your Honor. Mr. Williams will accept that plea of the time served with the balance probated.
All right. Mr. Williams, in case 22 CR 003811F, it's my understanding you wish to plead guilty to fare evasion and criminal trespass. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Your Honor.
Say it again for me.
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
Okay, I'll accept your plea, Mr. Williams. The sentence is going to be 12 months to serve 15 days, credit for time served 15 days, balance probated, 20 hours of community service, abide by any active MARTA suspensions, and no alcohol, drugs, or weapons while on probation. I am going to waive your probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the 20 hours of community service, it'll go to a non-reporting status, okay?
Yes, Your Honor. Thank you, Your Honor.
You're welcome. Good luck to you, Mr. Williams. Who do we have next?
Next, we have Mr. Young's, position 28.
Good morning, Mr. Youngs. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Was that a yes?
Yes.
Okay, thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Oh, yes.
Okay, you can put your hand down. Thank you, sir. Can I get the history, Ms. Harrison?
One moment. Cycles.
Sorry, say it again.
Last February, I'm sorry.
How many cycles?
Let me call you back. I'm in court, okay?
Okay.
I'm sorry, I didn't hear that, Judge.
Okay, I'll call you back.
Okay, 10 cycles, last arrest, February of this year, criminal trespass in Fulton County. No disposition listed on that arrest. A 2021 first offender, he's currently on, wait, one moment. No, he was convicted of burglary in the second degree in Fulton County. It's number 20 SC 177068. 1-year probation, and it was completed to time served. Doesn't indicate that it was sealed. He has a 2019 theft by shoplifting, no disposition listed. A 2019 criminal trespass, no disposition listed. A 2019 theft by shoplifting, misdemeanor conviction in Fulton County. And nothing further, Judge.
Thank you. Ms. Bacchus?
Maybe I missed something, Judge. What I have the 2019 theft is open, then he has a 2019 theft conviction, 2019 criminal trespass opens, a 2020 burglary in the second degree, which he got 1-year probation. Then he has a 2022 theft, which is open, and another 2022 criminal trespass that's open, and then our case. Your Honor, the facts of this case is that the officer was contacted by an individual at the Inman Quarter Apartments about a trespasser. The individual said that the defendant continued to enter various parts of the property. So they would come to the office, they would go to the pool, parking deck, be by the apartments, and they would even sleep there on the property at some nights, despite being given numerous verbal trespass warnings. So the apartment did provide surveillance video of that evening where the defendant is seen committing these trespasses and being on the property. We offered, I will say that we had a typo in our offer. And so it was 12 months, 20 days to serve. I think what they got was 120 days to serve. So it should have been 12 months, 20 days to serve, credit for time served, 11 days, balance suspended, stay away from that incident location, no alcohol, drugs, or weapons. And like I said, just based on the 10 cycles in the last 3 years, and 4 of them are criminal trespass cases, even though they're open, because he just fails to, I guess, respect property and people's wishes to keep him off of their property and refuses to abide by the court's instructions. We think that the 20 days is appropriate, as well as the other conditions, Your Honor. Nothing further from the state.
So I take it that that's a time served, Ms. Helen, that's.
Not quite. Mr.
Okay.
Younes was arrested June 14, 2022. I have 14 days of incarceration, but Judge, I'm asking for time served, balance suspended. Mr. Younes is residentially challenged. These incidences are when he is homeless, having nowhere to go, nowhere to be, Your Honor.
Hold on. But that's what Ms. Bacchus is offering, right?
I don't know.
So 20 days to
20
serve,
days.
credit for 11 days, and he's going to get 2 for 1. So that's
Okay. If
That's
that
11
was,
days.
I just wanted to make sure we got the numbers right, Judge, because the original offer was serve 120 days. So this is a
But
time served.
She amended that
Okay.
just now, so.
Okay.
And it
Um,
actually will be, so that was credit for time served 11 days as of 6/24.
Right.
Okay.
So it's 14 days.
So we could do serve 28, credit for time served 14. Just make sure our numbers are correct. Time served, balance suspended.
Well, I don't know if it makes a difference, 20 days. If that's what they're offering, if it were me, I'd take the 20 days Okay, whatever you want, Ms. Helen. If you want it to be 24 days, it's fine with the court.
Just to make sure I have that plea paperwork together. So I'll make sure I have it correct, Your Honor. I'll go with the serve 20 days.
Okay. Anything further?
No, Your Honor.
Nothing from the state.
And Mr. Joseph, did you understand what just happened
Yeah, I got time served.
with balance suspended?
Yeah.
Thank you, Judge.
Okay. Mr. Young, it's my understanding that in case 22 CR 003823F, you'd like to plead guilty to criminal trespass. Is that correct?
Well, I mean, sure, yeah.
Either you do or you don't. That's a yes or no question. Or would you like to plead guilty? If not,
Yeah, sure.
You need to talk to him, Ms. Helen. Apparently,
I
he has
do,
some
I
type
do.
of issue.
I do. Mr. Joseph, the judge requires a yes or no.
Okay, yes.
Are you under the, you've been represented by Ms. Helen. Are you happy with her representation? Again, that's a yes or a no answer.
Oh, yes.
Okay. Are you under the influence of any drugs or alcohol this morning?
No, I am not.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you've given up your right to a trial by jury?
Yeah. Oh, no.
Am I
No.
keeping you, am I keeping you, Mr. Youngs?
No.
Okay. Has anyone forced or coerced you to plead guilty?
No.
All right. I will accept the plea as negotiated.
Thank you.
All right. Good luck to you, sir.
Thank you, Your Honor.
Thank you so much.
Thank you, Your Honor.
Thank you, Miss.
Thank you, Mr. Joseph.
Position 2, Mr. Allen.
Do it on Zoom, Judge.
You all give me just 1 second. I have an attorney in court with me that I'm discussing a matter with. So give me 1 moment. Thank you.
Also, you're done?
Okay, I'm sorry. Where are we now?
This is position 2, Mr. Allen.
Okay. And what are we gonna do with Mr. Allen, Ms. Watson Cafe?
Plead not guilty, and we'd like to be heard on bond.
Okay, and he needs to be arraigned, is that correct?
Yes, Your Honor.
Good morning, Mr. Allen. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, I do, Your Honor, and good morning.
Thank you. Good morning. Can you raise your right hand for me?
Yes, I can.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I swear.
Okay, you can put your hand down. Thank you. Mr. Allen, you've been charged in case 22 CR 003728H with simple battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Watson Cafe?
Yes, Your Honor.
Mr. Allen, how do you plead to this charge? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Let's see, the bond that I have was issued on June 13th. It's a $1,500 good bond with a stay away and a no further contact. Is there a history, Ms. Harrison?
Your Honor, 26 cycles with history in Georgia and New Jersey. Last arrest, May of this year, failure to appear in Fulton County. Underlying charges, criminal trespass and simple assault. Record does indicate that's an open case. There's an open case for criminal trespass and simple assault. 19 CR 009051F. Also, there is an open probation for battery, 21 CR 005577E. Sentence May of 2022 with 12 months probation. Record indicates 2 failure to appear within the past 10 years. A simple battery conviction in 2012, 2014, and 2016, and in 2012, cruel to the children in the 3rd degree. Nothing further to add.
All right, Ms. King?
Yes, Your Honor. The state's position is that the bond should remain as set, the $1,500 surety, Your Honor. The 2021 battery family violence conviction, Your Honor, involves the same victim. The state is concerned for her safety and the safety of the public at large, Your Honor. Also, with the large amount of cycles, it shows the defendant is not willing to comply with the laws of the state nor the laws of the court and directions given by the court, Your Honor. He has multiple violent offenses and arrests on his criminal history, from simple battery all the way up to aggravated stalking, Your Honor. The state requests that the bond remains as set.
Ms. Watson Cafe?
Yes, Your Honor. He's been in Georgia for the past 12 years, vehemently denies these allegations. We look forward to this matter being disposed of by way of acquittal or dismissal. This dispute, without getting too much into the facts, involves an ongoing battle of custody over the 10-year-old child that they share together. As you're aware, he's been in custody for about 2 weeks on his $1,500 bond. He's been unable to post that bond. We are asking for a signature bond to allow him to be able to get out. Any concerns that the state may have can be addressed by way of conditions on the bond. A stay away order, a no further contact would be sufficient to address those concerns. Mr. Hall has a master's degree that he acquired back in 2012. He also has a bachelor's degree from Bluefield College that he obtained in 2010. I bring this up because he is certainly employable. He's in danger of losing his job, which would make the situation exponentially worse. He's also in danger of losing all of his assets as they're currently in storage. And he's in, it's my understanding in speaking to him that the storage facility has indicated that they are going to auction off his items if he does not basically retrieve them within the next couple of days. Again, I'm aware of his history, but with respect to these charges, Your Honor, they're vehemently denied. Again, it involves an ongoing custody battle over this 10-year-old child that he shares with the alleged victim in this case. And we do believe that these charges will resolve favorably. And we will resolve favorably toward him. So for those reasons, we would be asking for a signature bond. If Your Honor is not amendable to a signature bond, we would at least ask that it be reduced to a $500 bond, surety bond, to again allow him some ability to get out and move forward with this assisting me in his defense in this case.
Can he make a $500 good bond, Ms. Watson Cafe?
My understanding is he can't make any bond. I mean, the $1,500 bond, he's been sitting there for 2 weeks. So,
right. So if I reduce it to 500, I mean, it's the same as 1,500 that he has. Ms. King, it's my understanding that the state's offer was 12 months to serve 30 days, credit for time served 18 days, balance probated, family violence intervention program, and a stay away and no further contact. Is that correct?
That's correct, Your Honor.
Okay. As such, I am going to, and if you'll take it down, Ms. Watson Cafe, it's going to be a $10,000 signature bond through the jail, no further contact with Monifa, M-O-N-I-F-A Wilkins, stay away from the 3076 Elmwood Court address, no drugs, alcohol, or weapons while out on bond. And did you get that?
Yes, yes, I did.
All right, I'll give you the opportunity, Mr. Allen, but if you violate this bond in any way, you'll be right back where you are with a $10,000 bond. You understand?
Yes, I won't let you down, Your Honor.
Okay.
And Your Honor, I know you already made your decision, but I would like to address the court if at all possible.
Good morning, Mr. Walker.
Good morning, Judge Morrow. So I understand that you put the state's record on the record. you put the state's recommendation on the record. And that is correct. If he were to plead guilty today, he would not have to serve any additional jail time. And it seemed as though that you're using that as a rationale to give him a signature bond. But I would like to say that there is a difference between someone taking accountability, taking a guilty plea and enrolling into an FFIP class and being released on a signature bond. So while if he were to take a plea, it wouldn't be additional jail time, but there is something to be said about someone taking accountability, enrolling into FFIP versus just giving someone a signature bond. So I just wanted to place that on the record. I understand there is no additional jail time that we are asking, but there is a difference between a signature bond and being on probation and being in FFIP.
Yeah, I understand your position, Mr. Walker. Thank you for placing it on the record. My position in that is that he can't afford a $1,500 surety bond, which means that he can't afford a percentage of that. He's been in jail for some time now, and I think that that giving him a $10,000 signature bond and increasing that will allow him to get out and not lose his job, possibly. So, good luck to you, Mr. Allen.
Thank you, Judge.
All right.
Thank you, Judge Morrow.
You're welcome. Who do we have next?
Mr. Mack, position 16.
Okay. Good morning, Mr. Mack. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor. Good morning also, too.
Good morning. Can you raise your right hand for me, sir?
Yes, sir.
Do you swear from the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. This is a non-negotiated plea, is that correct? Is your
That is
case,
correct,
Mr.
Your
Ms. Helen? Who's representing Mr. Mack?
Ms. Helen is judge.
Ms. Helen, are you with us? Mr. Finley, can you possibly email Ms. Helen and let her know that the court's waiting on her?
Yes, I'll reach out to her right now.
Okay, thank you. Ms. Bacchus, in this case, what's the request for the amount of time to be served? I don't seem to have it on my calendar.
It looks like our offer was 12 months to serve. Credit for time served 11 days as of 6/24. Stay away from the incident location, no alcohol, drugs, or weapon.
Okay.
I reached out to her, judge. I'm not.
Okay, so let's see, can we take someone, that's Mr. Finley's case, he's 1 through 15, and come back to, I'm sorry, Mr. Mack. Or take Ms. Watson Cafe's, one of her cases.
What number is Finley?
I'm 1 through 15.
You ready for number 14, Mr. Lester?
Yes, sir.
Okay, Miss Helen, we've been waiting for you.
Apologize, Judge, I had to walk away. I apologize.
Okay. Well, when you walk away, you know you have half the cases that puts us in a bit of a bind, okay? But
Understood, Judge.
if you just let us know the next time you need to take a break, we'll be happy to take a break, okay?
Understood.
All right, so we are on in courtroom 2. Tell me again who we have in courtroom 2.
We got number 14 here on 5 South.
All right, so Miss Helen is with us now. Can we go ahead and finish up with Mr. Mack, position 16?
Yes, he's in courtroom 2, Judge.
Okay.
Thank you.
Let's see, let me just start this from the beginning. Good morning again, Mr. Mack. I'm Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Mack. Ms. Harrison, can you give me the history, please?
Yes, Your Honor. 29 cycles. Last arrest. One second, I'm sorry. Last arrest was February of 2019 for possession and use of drug-related objects. That was a misdemeanor conviction in Fulton County. A 2018 conviction for possession of drug-related objects. Record indicates 2 violations of probation within the past 10 years and an open probation for entering auto, case 18 SC 163734, sentenced March of 2019, 4 years probation. Additional felony conviction in 2016 for entering auto. Nothing further to add.
Ms. Bacchus?
Your Honor, okay, so the officers responded to a call about a package being stolen by an unknown male off their porch. And so on arrival, the victim, Mr. Wade Mark, common spelling for both names, notified officers that an unknown male had taken a package off the porch and that neither himself nor his husband had gave anyone permission to retrieve the package. So Mr. Mark provided the video footage from the doorbell system. And so at the time, the defendant wasn't identified, but based on that footage, they were able to identify the person. And so at a later time, an officer saw that there was the warrant out and saw the wanted individual at a different location. And I believe that was on June 9th. So the officer approached him and to place the defendant in custody. Your Honor, as to that criminal history, they have 10 cycles from 1985 to 1992 in Ohio, mostly for theft, breaking and entering, grand theft, robbery. And then they left, the defendant left Ohio, came straight here. So ended the theft charges in 1992 there, came straight to Georgia in 1993 and picked up the same type of charges, right? And so we've got, like she said, 2015, 2018, entering, and then multiple other theft charges on the record, or arrests on the record. And so I gave you the offer, Your Honor. It was 12 months, credit for time served, 11 days, stay away from the incident location, and no alcohol, drugs, or weapons. This defendant simply just really doesn't learn, Your Honor. He has an extensive history of theft, like I said, in both Ohio and Georgia. And he's been given probation and other conditions, which really has no deterrent effect. He also poses a risk to the community because his ability or his willingness to blatantly walk up to people's property and to take, as you know, that can escalate, right? And so that poses another issue, right? Violence for the community, possibly. And so because we can see that this defendant disregards the court's instructions, continues to reoffend, that's the reason behind the state's wanting the 12 months to serve, and nothing further from the state, Your Honor.
Ms. Helen?
Yes, Judge. So this is a non-negotiated plea. We are asking for time served, balance probated. Once the restitution is paid, we are asking for that probation to be non-reporting, Judge. When I went down and spoke to Mr. Mack, he is 63 years old. He does understand the seriousness of this charge. He's not denying it. Judge, he wants to resolve this case, not in a year to serve. We are asking for the time served. We are asking for the balance probated, so that he can report, show the court that he is on top of coming to probation, respecting probation, paying probation if need be, Judge. But we are asking for time served. We do feel like the year is egregious. And the restitution, as I have seen it, was $100. I think that was mentioned as the restitution cost. So Judge, again, he wants to pay restitution, but we are asking for time served with that balance probated. And upon completion of paying the restitution, we're asking for it to be non-reporting.
Your Honor, with all due respect, he's already shown the court, and that's all I have to say about that. He has shown the court that he doesn't respect the conditions that are put in place. So asking for him to be able to show probation, that he can actually abide by rules, I think that would be optimistic and hopeful, but not realistic.
And I'm sorry, Ms. Bacchus, did you ask for restitution?
We did not ask for restitution. I
Okay.
think what she's referring to is that the victim said that the contents of the package were about $100. We're not asking for the restitution, but because of his extensive history, 12 months to serve is appropriate in the state's, from the state's position.
Where's the stay away location?
Give me 1 second. The stay away location, I believe, is 781 Myrtle Street Northeast. Unit 200, it looks like, 781 Myrtle Street Northeast, and then Atlanta, Georgia, 30303.
Okay, on his bond, it says 795 Myrtle Street.
I'm looking at the Atlanta police report, and it just says offense location. I'm trying to see if there's another. That's where I'm getting the location from. And on 7 or 8 pages, it has that same address, 781 Myrtle Street.
Okay.
And Your Honor, Mr. Mack also has employment that he believes he'll be able to re-enter to, Mary Mack's, where he is a full-time cook, where he's been working for the last 6 to 7 months. If he's able to be released on the time served, Judge, but if not, he will lose that opportunity for employment.
So it's going to be 12 months to serve, 60 days, credit for time served, 15 days, balance suspended, if that's what he wants to.
Mr. Mack, do you understand what's happening? The judge is recommending a sentence of 60 days. That would be 15 additional jail days with the balance suspended. That means no probation, correct, Your Honor?
Yes.
Is that something you would like to accept today, Mr. Mack?
Yes, ma'am.
Your Honor, Mr. Mack will accept your recommendation of serving 60 days, 15 additional jail days, balance suspended.
Mr. Mack, it's my understanding that in case 22 CR 003822J, you'd like to plead guilty to theft by taking. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury and that by pleading guilty, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea, Mr. Mack. The sentence is going to be 12 months to serve, 60 days, credit for time served, 15 days, balance suspended. You're also to stay away from the Myrtle Street, 781 Myrtle Street address. You understand?
Yes, sir.
All right, good luck to you, sir.
Thank you, sir.
Yes, we got number 14, Mr. Lester.
Okay.
Good morning, Mr. Lester. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you, Mr. Lester. Can you raise your right hand for me? Mr. Lester? I think they're frozen. Oh, there you go. Can you hear me now, Mr. Lester?
Yes, Your Honor.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down. It's my understanding that this is a negotiated plea, Mr. Finley.
That's correct, Judge.
All right, Ms. King.
Yes, Your Honor. The state's recommendation for death by taking, 12 months to serve 13 days, credit for time served 13 days with the balance probated, completing a theft class, and no further contact with John DeBoe, John traditional spelling, DeBoe, D-E-B-O-E, and a stay away from the incident location, 1025 Robert Smalls Way, Northwest in Atlanta.
Okay, thank you, Mr. Finley.
Yes, Judge, that is our understanding of the offer, of which we do agree. Would just ask that the probation fees could be waived, and additionally, that once Mr. Lester does complete that theft class, that the balance of his probation could be terminated.
Any objection, Ms. King?
No objection, Your Honor.
All right. Mr. Lester, it's my understanding that in case 22 CR 003754G, you wish to plead guilty to theft by taking. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea as negotiated, Mr. Lester. I'm going to waive the fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it's going to terminate, okay?
Yes, sir.
All right. Good luck to you, Mr. Lester.
And then I see Mr. Johnson is seated in courtroom 2. If we could hold off on his till a little bit later, we're looking into something on his behalf that would impact whether he takes a plea or not.
Okay.
Position 9, Mr. Hoser.
Good morning, Mr. Hosier. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. Thank you, sir. You've been charged in case 22 CR 003818G with theft by receiving stolen property. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Watson Cafe?
Yes.
How do you plead to this charge, Mr. Hosier? Guilty or not guilty?
I'm not here.
We'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Anything further on Mr. Hosier?
I would like, I mean, he has holds, but I would still like to be heard on bond, Your Honor.
Okay. Where his holds out of, or why don't we do this?
Fulton, he has felony holds. I don't know I still want to be heard on a bond reduction in this case, though, Your Honor.
Okay, that's fine. Ms. Harrison, do you have the history? And may I get that bond order? No.
Let's see, 7 cycles. One moment, Judge. Okay, 7 cycles, last arrest, October of 2021 for burglary in the second degree, theft by taking, criminal trespass, forgery, fourth degree, and theft by receiving stolen property in Fulton County. That is an open case 21 CP 203547. Additional open case burglary, second degree, theft by taking, criminal trespass, damage to property, 21 CP 20353. Additional open case. He has 21 CP 203537 for burglary, second degree, theft by taking, and criminal trespass. 21 CP 2033547, forgery, fourth degree, theft by receiving stolen property, 3 counts, criminal trespass, 2 counts. Additional open case, 21 CP 203552, criminal trespass, theft by taking. Additional open case, 21 CP 205030, criminal damage to property. Additional open case, 21 CP 205031, burglary, second degree, 3 counts, theft by taking, 3 counts, criminal damage to property, second degree. Nothing further, Judge.
Thank you. Ms. King?
Yes, Your Honor, the state requests that the $2,000 surety bond remains in place. Your Honor, this incident was planned. It occurred at the Q-Smart located in Atlanta, where the defendant was seen on video with a U-Haul truck pulling up to the storage facility, breaking into the victim, Courtney Stewart's rental unit and taking his property, Your Honor. All of this was recorded on video, which is how the defendant was identified. You've heard the extensive criminal history as well as the open cases from pretrial. This defendant is not following the rules, Your Honor, and he's not following the rules of the court. The $2,000 bond is appropriate in this case, Your Honor.
Your Honor, I apologize. He has 2 additional open cases, 22 SC 180532. That's burglary, 3 counts, and theft by taking, 3 counts, and 22 SC 181000, burglary, second degree, and criminal damage to property, second degree.
This defendant is a threat to the community at large. He commits multiple thefts, felony thefts. He's escalating, Your Honor, and I ask that the bond remain in place.
Ms. Watson Cafe?
Yes, Mr. Hoosier is a lifelong resident of Georgia. He has a 1-year-old son. From what I heard, all of these cases are open, which means there aren't any convictions. He enjoys the benefit of being presumed innocent at this stage. And so I would ask at least that Your Honor would take that under consideration. It's my understanding that prior to his arrest, he was taking GED classes in hopes of obviously obtaining his GED and furthering his education. And speaking with Mr. Hoosier earlier today, also my understanding that he has some mental health challenges and physical challenges that may explain some of the conduct. Again, we deny these allegations, but it's my understanding that he's had some mental and physical medical challenges that may explain some of the conduct that he's been accused of. He also has a 1-year-old son that he was providing for financially, but provides for emotionally. So we would ask that the bond be reduced to either a signature bond or bond of $500, a surety bond of $500.
Okay, I'm not inclined to change the bond at this point in time. Good luck to you, Mr. Hoosier.
Your Honor, can I inquire about Don Travius Williams? I don't know if he's on this calendar. He's been reset twice. I believe he's just picked up on a bench warrant.
I have him on an add-on calendar, Ms. Watson Cafe. I don't know if everyone received that add-on calendar. I'm being told. Do we know whether we have Mr. Don Travius Williams, number 3 on the add-on calendar today?
I have another officer on the floor that's doing his case. He's not in courtroom too.
Okay, but he is going to be with us today. Is that right?
Let's see, let me double check. What's the name? Dontavius Williams?
Yes.
I don't even see him on the full sheet.
He was on the add-on calendar, and I don't know if you all
Oh.
received that
In
in time.
my other call. I can find out.
Okay, thank you.
You're welcome.
Okay,
As
we'll find
far
out,
as-
Ms. Watson Cafe.
Thank
And
you.
Your Honor, I'm not sure if we received it either. If Ms. Grace
We
has the
didn't,
calendar,
yep.
if she could email it to me, please, and we can
Okay,
get started, I guess.
I was
All
gonna
right.
say, Judge, I don't believe the PD's office received an add-on calendar either.
okay. So if we can get everyone the add-on calendar. And I don't know when it went out, so. Okay, so who do we have that we can?
The last case that I have, Judge, in courtroom 2 is gonna be Mr. Marcus Johnson, position
Yeah.
12.
And I just need to speak with him briefly. I just tried to call it, didn't go
You
through.
can call back again, Mr. Finley.
Okay. So can we go somewhere else while that's being accomplished? Do we have anyone else that's ready to?
Go ahead. That's it in courtroom 2. I'm trying to see if my other officer is signed on.
Okay, just let us know. And are we gonna have anything at the South Annex today? We still have a number of people on the calendar.
Judge, you heard me?
Hello.
Oh, no, I didn't.
Yeah, the screen froze. I'll go ahead and call South Annex too.
Okay, all right, thank you.
You're welcome.
And Judge, do we have, good morning, Judge. I have someone, he's here, but I'm presuming we're getting through the jail cases first before we take other people.
Well, I'm happy to take, as we wait, whoever we need to take.
This is Chalel Francisco. I believe he was transferred to your court from a different courtroom via the notes that we have.
And is he in custody?
He's not in custody, Your Honor. He's supposed to be arraigned.
Okay. And what calendar would that have been on?
We don't know, Judge. We didn't receive a calendar. We received a Zoom link saying that he had a hearing this morning.
Okay. Tell me the name again.
Chalel Francisco. I do also have a case number.
Okay. And can you spell that name for me, please?
Yes, I can. So his first name is Transito, Transito. Middle name Osbely, Osbely. Last name Chalel, Chilel. And then there's a hyphen and Francisco, Francisco.
And the case number?
We have 22 CR 003758.
Okay, we'll find out
Judge.
about that. Okay.
Judge, you said the name of the person that you're looking for is Dontavius Williams?
Yes.
Okay.
Fabius with an R. Dontravius Williams.
Okay.
Okay, thank you.
Ms. Champion, are you there?
Yes, Judge.
Do you have any information on this Chilel Francisco?
I'm looking him up now.
Okay, thank you.
All right, Judge Morrow, I'm ready to address Mr. Johnson's case.
Okay.
Whenever you are.
Good morning.
What position is that, Mr. Finley?
This is position 12.
Well, okay.
Yeah, position 12, Judge.
And
He's right here in courtroom 2, Judge.
oh yes, I'm sorry. I'm trying to address someone else.
Sorry about that.
Chilel Francisco, who was inquiring about, do we still? I don't. Oh, there you go, Ms. Luncheon. It's my understanding. I've been told that he has made bond.
That's right. He's on the Zoom. He's not in custody.
Okay, so, and okay, I'm told that he's going to be reset to Judge Richardson's, who is the original judge on the case, that will be reset to his calendar.
Okay, Judge, yes. And that we saw that there was an order. We were told it was reset to your calendar, but
okay,
I would think it would be combined because he does have an older DUI. And so it should be transferred to whoever was handling that first case.
Okay, so I think that's going to be returned to Judge Richardson, is my understanding.
Great. Thank you, Judge. I
Okay.
appreciate that. Thank you.
You're welcome. Have a good day.
You too.
Okay, so this is Mr. Johnson, position number 12. What are we going to do with Mr. Johnson this morning, Mr. Finley?
Yes, Judge, we're going to address bond.
Okay, he needs to be arraigned also.
Yes, sir.
Good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Is that a yes?
Yes, sir.
Okay, you can put your hand down, Mr. Johnson. You've been charged in case 22 CR 003524A with battery, family violence, and cruelty to children in the third degree. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
Yes, Judge.
How do you plead to these charges, Mr. Johnson, guilty or not guilty?
Not guilty.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Let's see, what's the history? Ms. Harrison?
9 cycles. Last arrest was March of 2020 for aggravated assault and possession of firearm during the commission of a felony. No disposition on that arrest. (2016) misdemeanor conviction, DUI under the influence of alcohol. 2018 battery, family violence, first offense, conviction. 2015 possession of marijuana less than an ounce, misdemeanor conviction. 1 second. Nothing further, Judge.
Thank you. Ms. King?
Yes, Your Honor, the state requests that the bond remained as set. This defendant has been very violent. He has opened very violent offenses, aggravated assault with a deadly weapon. It involved a firearm, Your Honor. The victim in our case was present. While she was not the victim in that case, she was present and was the one that actually reported that to the cops. He also has an open battery, family violence, which does involve this victim, Your Honor, in addition to this case. And on the day in question, they got into an argument and the defendant did body slam the victim, Miss Dorothy Tapley, in front of their minor child, Davion Clark. This is not the first time he's been violent from speaking with our victim, and the state is greatly concerned for her safety and the safety for others at large. As I say, with the aggravated assault, that was a separate person and he was violent towards that person too. So it shows that the violence isn't even focused towards Miss Tapley in this case. It could be for anyone, Your Honor. So the state requests that the bond remains as set.
What's the breakdown of the bond? Do you have that, Ms. King?
I was just actually looking on Jail Manager, and the only thing it says is no bond. It doesn't give an amount in Odyssey, Your Honor.
Do you know the bond amount, Mr. Finley?
Judge, that was going to be my next question once Ms. King finished, is what I'm missing, because I'm not seeing a bond.
That is correct, Your Honor.
Okay, so I'll need to set a bond for him regardless. Okay, Mr. Finley.
Yes, Judge. Now, obviously, as Ms. King stated, I would prefer for the bond not to remain the same, as we just, made clear that there is no bond. Mr. Johnson has 3 kids, ages 17, 7, and 3. He has been incarcerated now for 10 months. So he's been sitting within a cell for 10 months, has no bond. He is eager to get out and get to his kids. I do understand the seriousness of these charges, but they are allegations, and he is innocent until proven guilty, and is presumed innocent on these charges. He is very involved with his kids' lives. He has lots of family in Atlanta, so he is in no way a flight risk. He does have community ties and just eager to be with his kids, Judge. So we are asking for a $2,000 surety bond to be set, as he needs as low a bond as possible, as he clearly has not had any income from being incarcerated for the past 10 months.
Okay, so he's incarcerated on something different than these charges though, right?
That's correct, Your Honor. And at this time, the state is requesting a cash bond due to him having open felony cases and another open battery, family violence against the same victim. A $5,000 cash bond is the state request.
And he does have an alternate address to stay at, and he has no problem not having contact with Miss Dorothy. So he will 100% abide by a no contact judge, but he would hopefully be able to fight this charge, but from the outside instead of in.
Okay, what's the stay-away address, Ms. King?
My apologies, Your Honor. It's 320 Fairburn Road Southwest. And the victim name is Dorothy Tapley, Dorothy Tapley.
Okay, so for the battery, it's going to be a $5,000 good bond. For the cruelty, it's going to be a $1,000 good bond, making it for a total of a $6,000 good bond. No further contact with Dorothy Tapley. Stay away from the Fairburn Road address. No drugs, alcohol, or weapons while out on bond. Did you get all that, Mr. Finley?
You actually cut off for a second. Can you repeat
That's
the breakdown?
That's fine. 5 good for the battery. 1 good for the cruelty. No further contact. Stay away. No drugs, alcohol, or weapons.
Got it. Thank you.
Okay. Good luck to you, Mr. Johnson.
Thank you.
All right, we got number 1, Mr. Fawana Soban.
Okay, I'm sorry. Who is this?
Number 1, Mr. Fawana Soban.
On the probation
Okay, this is-
violation?
Probation case. Okay. Let's see. Who do we have on from probation?
Good morning, Your Honor, Ms. Harris.
Good morning, Ms. Harris. How are you?
I'm doing good. How are you?
I'm doing well, thank you. Let's see. Go ahead, Officer Harris.
Yes, Your Honor. My apologies. What was how you pronounce his name again?
Newen. Which one? Which one, Newen?
Nuan.
Okay.
Yes.
Oh, Mr. Nuan. Okay. So Mr. Nuan was sentenced to probation on September 28th, 2021. Nope. My apologies. September 14th, 2021. He was ordered to complete 12 weeks of anger management. As of today, he did not report to our office, have provided proof of his classes. He has 2 months and 14 days left on his case. Probation recommendation is to revoke his remaining balance on probation.
2 months and how long?
14 days, Your Honor.
Okay. Ms. Helen?
Yes, Your Honor, this is a probation revocation hearing. I do hear what Officer Harris has stated. When I went and spoke to Mr. Nuan, I saw in Odyssey that there was a final disposition of September 14, 2021 from you, Judge, for entering in probation. However, when I spoke to him, he had immediately became homeless. He became residentially challenged and began to live on the street. He was immediately homeless after that court date, Judge. And when I spoke to him, he had no idea about the probation for this case. I had to inform him, yes, you were on probation. I don't have that you reported or did 12 weeks of anger management. When I spoke to him, Judge, he has been incarcerated since January. So homelessness right after that case, incarcerated January 19th of this year, has been incarcerated for 161 days. He didn't have the money. He was homeless on the street. And when I spoke to him, Judge, I gave him all this information. He wants an opportunity to complete this probation and report to it. Right now, he does have felony holds. So we are asking for him to be given an opportunity to continue on his probation, to continue and complete those 12 weeks of anger management. But again, due to residential homelessness, as well as being incarcerated, he was not able to complete any of those conditions for probation.
What does he have a hold for, Ms. Helen?
Burglary, Your Honor.
Okay, so you think that he just want to, since he's probably not going to get out on the burglary charge, that you think that he just want to finish up and get this behind him with the 2 months and 14 days being revoked, getting 2 for 1, and then he'd be done, right?
Yes, Your Honor.
So I think I'm going to follow the recommendation of Officer Harris and the probation department and revoke the 2 months and 14 days, and then he'll be done with this matter and can put it behind him.
Mr. Nuon, did you understand that?
Yes.
Understood.
Okay, good luck to you, sir.
Is it I'm going home or what? Is it I'm going home?
And for South, can I get a number? I want to speak to Mr. Nuon, make sure he understands what's happening.
Of course, I don't have a phone available. You want to do a breakout session real quick?
Yes, can I be allowed to have a breakout session with Mr. Nuon?
Okay, that's fine. So if we can put them into a breakout session.
Excuse me, Your Honor, that concludes my business. May I be excused?
Oh, yes. Have a good afternoon. And I am in G33 if you want to get me the paperwork.
Yes, sir. Thank you.
Okay, you're welcome. Well, I guess we will be in recess until someone else from the jail comes back on.
And Judge, I have spoken to Mr. Nguyen. He is now under the understanding of the probation violation and what just occurred. I did inform him of his booking screen. I think there may have been some confusion as with his other charges, but he is clear about the probation violation.
Okay. So it remains as ordered. Good luck to you, sir. All right, so we're in recess until, do we have anybody else at 4 South?
Oh, yeah, we do have that, number 19, Mr. Old.
I'm sorry, who do we have?
Number 19, Mr. Osby.
Okay.
And Your Honor, Mr. Osby has declined the services of the Public Defender's Office and would like to enter at pro se and would like help with that pro se process, Your Honor.
Okay. Good morning, Mr. Osby. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good morning, Your Honor.
Good morning. Let's see, Mr. Osby, you have a right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present at these proceedings. You have been offered to have representation by the Public Defender's Office today, and it's my understanding that you are declining their representation. Is that correct?
That wasn't not necessarily, it was a misunderstanding between me and.
Mr. Osby, I'm sorry, I can't understand what you're saying, sir. So either you're gonna have to scoot up a bit. So my question was in regards to the public defender. We've offered you to have the public defender represent you today. And do you not want to have them represent you?
Yes, I do, sir. Yes, I do, sir.
You do wish to have them? Okay, all right. So I think that's a good, Ms. Helen?
Yes, Your Honor.
Okay, so he does want your representation. So would you mind speaking with him?
I've spoken with Mr. Osby. Can we just have a breakout room just to make sure we're on the same page?
Okay, so can we put 4 South and Ms. Helen into a breakout room, please? All right, again, we'll be in recess. Ms. Watson Cafe, I'm sorry.
Yeah, is there any update on my?
Well, they're gone now, so.
Okay.
That's the first thing I'll take up when they come back, okay?
Okay, thank you.
You're welcome.
Already on position 19, Judge, this is going to be a bond hearing.
Okay, let's see. And has he already been arraigned? He needs to
No,
be arraigned also?
Yes, Your Honor.
Right. Ms. Watson Cafe, can you sound for your, or ask the jail, which one was your client?
Don Travius Williams.
4 South, do you have a Don Travius Williams?
No, sir.
I'm sorry, what was the answer to that question?
No, sir.
Okay, do we know if someone's trying to track down Mr. Don Travius Williams?
Me and my colleagues on to courtroom 2 to look for him.
Okay. Mr. Oxby, can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down. Mr. Oxby, you've been charged in case 22 CR 003744B with simple assault and simple battery in a public transit vehicle or station. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Your Honor.
How do you plead to these charges, Mr. Oxby? Guilty or not guilty? Say it again?
Not guilty, Your Honor.
Okay, not guilty. We'll record your not guilty plea. Your case will be returned to the division judge, and you will receive notification of your next hearing date. I have that bond was set on June 13th, $1,000 good bond on each charge, making for a $2,000 good bond. And it looks like that I'm having some computer problems, so I'm going to have to log out and log back in. I'll be right back with you.
Understood, Judge.
Okay. What is
I guess your video keeps cutting out, Your Honor.
Yes, it does. Not sure what the problem is. Hold on. Okay, there we go. Is there a history? Ms. Harrison?
9 cycles, Judge, out of Indiana and Mississippi. Last arrest was October 2019 for domestic battery, felony, and criminal confinement felony out of Indiana. No disposition listed on that arrest. GCIC does indicate there's a hold in Ohio for failure to appear. Nothing further to add.
Okay. Ms. Bacchus?
Yes, Your Honor, 1 second. Okay, and so the facts of this case, Your Honor, is that the officers report that defendant and the victim, Anthony Durham, common spelling, were at the College Park MARTA station when the defendant randomly began approaching the victim and yelling profanities and aggressively entering the victim's personal space. Fearful for his safety, Mr. Durham turned the other way and tried to get away from the defendant, and the defendant kicked him in the back. And so our offer, Your Honor, on this case was 12 months, 60 days, credit for time served 13 days. That's as of 6/24. The balance probated, anger management, no further contact with the victim, Anthony Durham, and a stay away from the incident location, which is the College Park MARTA station. The state really has concern about this defendant and the safety of the community, as this was seemingly an unprovoked attack. He has a DV conviction in 2002 and 2 counts of domestic battery in 2019, which one could argue that the 2002 charges were remote, but that's somewhat irrelevant because he hasn't really learned, right? He's got these other charges in 2019. He apparently has an issue with violence and has no regard for it being in a public place and a random citizen. And so for this reason, Your Honor, the state feels as though this recommendation is fitting. Nothing further from the state, Your Honor.
Ms. Helen?
Yes, Your Honor, this is a non-negotiated plea. We are asking for time.
I thought this was a bond hearing.
Oh, I'm sorry, Your Honor. This is a bond hearing.
My apologies. I thought that this was a non-negotiated plea. My apologies.
Okay, so we're all on the same page.
It's a bond hearing. I apologize, Your Honor. I heard.
Okay, that's fine.
Reacted in verbiage, but this is a bond hearing. Mr. Osby is 41 years old. He is employable. He has previously had employment with, he's a barber, barbershop corner cuts, barbershop's infamous styles, and he's been employed, Your Honor. And let's talk about the Ayala factors. He does not have a violent, aggressive, historical criminal history, Indiana or Mississippi. I understand the domestic cases, but that wasn't with the alleged accuser at this moment in this case. And with this case, it's not random. Mr. Durham, the alleged accuser, assaulted verbally and physically Mr. Osby at a Metro PCS store 2 days prior to. Mr. Osby actually called from the store, the corporate office. He did not call the police, but he did inform Metro PCS of what that employee was doing towards him in the store. 2 days later, Mr. Osby saw Mr. Durham at the College Park location and was trying to protect himself because, again, Mr. Durham offered violence towards Mr. Osby. He was just trying to protect himself. Again, this is not a reoccurring event. This is also not just a random community person. Mr. Osby is not a danger to the community. He's not a danger to this alleged accuser. He's also not going to reoffend. He does not have the history for it. And he's going to come to all his court dates, Judge. We are asking for a signature bond for this case. Again, Mr. Osby was trying to protect himself from violence being offered to him by this individual who he had reported to Metro PCS corporate office. As the MARTA police approached him, he tried to tell him, this individual tried to assault me. And MARTA did not make any record of that. And so I am asking for a signature bond for Mr. Osby. If not a signature bond, we are asking for the lowest bond possible because, again, Judge, the bond was set June 13th. He hasn't been able to make it. He has lost all employment, current employment, due to this incarceration after he was offered violence from this alleged accuser. So, Judge, we are asking for a signature bond. And if not that signature bond, we are asking for a bond reduction again because Mr. Osby has not been able to make that bond since the 13th, Your Honor.
All right, I'm not going to give him a signature bond, Ms. Helen, but I'll lower the bond to a $250 good bond on each charge, making for a total of a $500 good bond. So if you want to take this down for us.
Yes, Your Honor.
No further contact with Anthony Durham. stay away from the College Park MARTA station. No drugs, alcohol, or weapons while out on bond.
Mr. Osby, did you hear what just happened?
Again, ma'am.
Say it again, Mr. Osby, you're a little low.
Explain that again to me, ma'am.
You were not granted a signature bond. You were granted a modification to $500 surety, $250 each charge,
$500.
$500 surety. Are you hearing me, Mr. Osby? Okay. And is that, well, Judge, he did hear.
Okay, so you can talk to him later, Ms. Helen. All right, good luck to you, Mr. Osby. Who do we have next at 4 South?
Number 11, Mr. James. James, come on.
Sorry, Your Honor, what position did he say?
11.
11.
Thank you.
All right, good morning, Mr. James. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Read that, sir.
Yeah, we're doing this by video this morning. Do you agree to have your case heard by video?
Yes, sir.
Okay, thank you, Mr. James. Let's see, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down, Mr. James. Mr. Finley, this is a negotiated plea, is my understanding.
That's correct, Judge.
Ms. King?
Yes, Your Honor, the negotiated terms are as follows. For theft by taking, 12 months to serve 10 days, credit for time served 10 days with the balance probated, and MHE, and a stay away from 227 Peter Street Southwest, and no further contact with Eric Delfino, ERIC DEFINO.
And, yes, Judge, that is our understanding of the offer, of which we do agree. And would just ask that once he does complete the MHE, that the balance of his probation could be terminated.
Any objection, Ms. King?
If after the MHE, they determine that treatment is required, the state requests that he stays on probation through his treatment. But if no treatment is required, the state has no objection to terminating the probation.
Okay, so it'll terminate, if there's treatment required, it will terminate after the treatment. If treatment is not required, it'll terminate at that time. Okay.
That sounds good, Judge. That sounds good with us.
Which last name? Ms. King, would you spell the victim's last name again for us? You're not on mute, but we can't hear you.
I'm sorry, it's DEFINO.
Okay, thank you. Mr. James, it's my understanding in case 22 CR 003820E, you wish to plead guilty to theft by taking, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
One more time, sir.
You've been represented by Mr. Finley. Are you happy with his representation?
Oh, sir, yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Sir, yes, sir.
Has anyone forced you to plead guilty?
Sir, no, sir.
I am going to accept the plea as negotiated. Mr. James, I'm going to waive the fees for you while you're on probation to help you get and stay on your feet. And if treatment is not necessary, then the probation will terminate, and it will terminate if treatment is necessary after you receive treatment. Good luck to you, Mr. James.
Perfect, sir. All right, next is that number 17, Mr. Marshall.
It's an arraignment and a bond hearing, is that correct?
Yes, Judge.
Okay. Good morning, Mr. March. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
I didn't hear you, sir.
Good morning, Mr. March. Did you hear my question? Do you agree to have the case heard by video?
Yes, sir.
Okay, thank you. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Marcher. You've been charged in case 22 CR 003812Y with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Your Honor.
How do you plead, Mr. Marcher? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge and you'll receive notification of your next hearing date. Let's see, do we know what the current bond is?
Your Honor, that's $1,000 surety bond.
All right, I set this bond back on June 14th. Let's see, Ms. Bacchus.
All right, Your Honor. Again, this is $1,000 surety bond. Essentially what happened is that officers responded to a dispute call when they arrived. The victim, Montera Trammell. Montera is spelled Monterra. Trammell is spelled Trammell. So the victim was sitting on the curb crying when the officers arrived. She was upset. She stated that her and the defendant, whom's her boyfriend, had gotten into an argument because he attempted to take her cell phone. The fighting began, at which time a woman that was in her car driving yelled out to them to stop fighting. At that time, the defendant then threw the phone at the victim, hitting her in the face. So the officers did observe that Ms. Montera had a cut on her cheek as well as blood coming from the inside of her mouth. The officers took the defendant into custody, at which time the defendant said he only threw the phone in a downward motion and didn't see where it went. But Your Honor, I would caution the court that that doesn't really make sense because you wouldn't have a gash in your face from someone throwing a phone in a downward motion unless they were 10 feet tall and you were 2. So Your Honor, really, though this defendant doesn't have an extensive history in Georgia, this is their first charge in Georgia, he does have a pretty serious record in Oklahoma. And so that's violent offenses. And so he knows better. Yet he continues to use violence as a means to control people. And due to the fact that he has an extensive history in Oklahoma and no real ties to this community as he's just recently moved here, we believe that serving certain days in jail is appropriate. I believe we offered, well, we don't have to go into the offer because we're talking about the bond, but we do believe that the bond is appropriate. $1,000 surety bond is not excessive due to the nature of what occurred. Nothing further from the state.
Thank you, Ms. Helen.
Yes, Your Honor, this is a bond hearing and you are correct. You did. I see that you set that $1,000 surety. Mr. Marcia has not been able to bond out since that $1,000 surety has been made. And from speaking to Mr. Marcia, I am asking for a signature bond. He is 21 years old. He is employable, was working at Willie's Mexicana Grill for 2 years. Due to being incarcerated, has lost that employment. He is a high school graduate, has 1 year of Metro Tech experience, college experience. And again, Judge, these are allegations in this case, and that's why he is pleading not guilty to fight these allegations. Judge, we are requesting that signature bond because I do believe he does not have a history here in Georgia. I do hear the history in Oklahoma, but that history does not involve anyone here. And Judge, we are asking for that signature or that surety be bond to be modified to a signature bond. Again, Mr. Marcia has no one helping him to bond out, has, again, no income from being previously losing his job at the Mexicana Grill to help bond himself out, Judge. So we are asking first for that signature bond. We are, if you feel that he is ineligible for that signature bond, we are asking for a bond reduction of no more than $500 for this battery family violence. Again, Mr. Marcia cannot afford any other bond and has sat here because of that, Your Honor.
Your Honor, I do also want to just point out, and I didn't realize, but he also has active warrants in Oklahoma. So these are not things that are too remote in time. These are fairly recent things, offenses that he's committed.
Okay, Ms. Harrison's telling me that she shows 1 arrest in Oklahoma with no disposition. Do you have anything other than that, Ms. Bacchus?
So what I see in Oklahoma is 3 cycles. There's a 2016 rape in the first degree, I guess, assault and battery, 2018, 2 counts of the same in first degree with, let's see, we've got kidnapping, 2020 DV battery with a dangerous weapon, and marijuana possession and drug paraphernalia, which really what's of concern there is the DV battery.
And Your Honor, do we have any dispositions in these cases? I know he's on probation for felony probation for one case. Are there any dispositions in the other cases?
I apologize, as I wrote down the criminal history, I did not put, I typically put whether it's a conviction or just an arrest, and I did not do that here. And so I'm not sure. And that the NCIC may not have shown that.
And Your Honor, I just brought that point up because I don't have those convictions. I have that he is on probation, has been consistent on that probation, and that this is his first arrest in Georgia.
If he's does pretrial have that he does have active warrants in Oklahoma? Because that would not be consistent with probation.
I'm not showing any warrants.
Oh,
I'm only showing one arrest in Oklahoma, and that was in 2016. It is a CWAC charge.
I do have, as I said, Your Honor, I do have an NCIC with those 3. And if he's on probation, that means he was convicted of something, but I do have the NCIC with those 3 charges on there.
Well, he's
And I
21
didn't
now,
fully,
so it's possibly maybe juvenile.
that could be. That's probably what it is. I guess so the 2020 would have been the conviction that he would have been on probation for, is that correct? The DV battery with the dangerous weapon, drug paraphernalia, and marijuana possession.
Okay, well, I don't believe that I heard that, the underlying charge at the SCA calendar when I issued this bond, because I believe that I would not have set $1,000 good bond with what I'm hearing today. I'm going to leave the bond where it is at the present time. All right, good luck to you.
Mr. Marsha, did you hear what just happened? Mr. Marsha, did you just hear what just happened?
I heard.
Okay. Okay, thank you.
All right, next, number 13.
Judge, we have Mr. Dontavius Williams in courtroom 2.
Okay, who do we have in courtroom 2?
Dontravius Williams.
Okay. And Mr. Williams is number 3 on the add-on calendar. Ms. Watson Cafe, what are we doing with Mr. Williams today?
It's my understanding he's here on a bench warrant. We would be asking for his bond to be reinstated or for a new bond to be issued, a signature bond to be issued for his release, Your Honor. I can go into argument if.
So he received a criminal trespass, family violence, battery, family violence, reckless conduct. He received a bond on those, and he missed a court date.
That is correct. That's correct, Your Honor. And I would also ask that pretrial recess history, because it is quite extensive and there is violence in his past.
And what court date did he miss?
It was May 16th in front of Judge Morrison.
Yes, Your Honor.
Okay.
But I can provide more information when Your Honor's ready.
Okay, well, I'm happy, but generally when another judge issues a bench warrant for missing a hearing, I'll have you go back to that judge, since they were the ones to issue that. So that's my normal practice, and
that's what the state will be requesting. And I also looked at an order that was issued by Judge Morrison, and in that order, it literally states that the defense was unable to provide any reason as to why the defendant was not present. So it will be the state's position that because Judge Morrison has issued an order, he is on a $3,500 bench warrant, that this case is sent back to the division judge for Judge Morrison to make the ultimate determination. But again, if necessary, I can have pretrial go into the history. It is quite extensive, and this is his second battery family violence with the same exact victim. So just considering everything I just stated, I think it would be most appropriate that Judge Morrison would rule on this.
Ms. Watson Cafe, that's my normal practice. I'm in agreement with Mr. Walker. So if you like a bond modification, you'll have to go back to Judge Morrison for her to do that, okay?
Okay, we'll file for that today. Thank you, Your Honor.
All right, you're welcome. Is that your
Mr.
last?
I'm sorry.
Go ahead.
I was just going to let Mr. Williams, I'm going to come down to the jail, speak to you, okay?
Okay, thank you,
Right.
Ms. Watson.
Thank you, Your Honor. And may I be excused?
Yes, have a good rest of the day.
Thank you, Your Honor. You too.
We're completed here in courtroom 2, Judge.
All right, very good. I'll see you this afternoon.
Okay, thank you.
Let's see. I see that it's, I know we have,
Got number 13, Mr. Katz.
okay. Good morning, Mr. Katz. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Hey.
How are you, Mr. Katz? Did you hear what I said?
Yeah.
Okay. You've been charged in case, well, can you raise your right hand for me, Mr. Katz?
Raise your right hand.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
All right. Thank you. You can put your hand down. Ms. King?
Yes, Your Honor. Is this a negotiated plea?
That's my understanding.
Okay. For the criminal trespass is 12 months to serve 12 days, credit for time served 12 days with the balance suspended, and a stay away from the College Park MARTA station. For the fare evasion, it'll be 12 months probation to be served concurrent, can terminate.
Mr. Finley?
That is our understanding of the offer, Judge, of which we do agree, and that stipulate the factual basis, ID, and venue.
Mr. Katz, it's my understanding that you wish to plead guilty in case 22 CR 003755E to criminal trespass and fare evasion. Is that correct?
Yeah.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by Mr. Finley, and are you happy with his representation?
Okay.
You understand that you have a right to a trial by jury on these charges, and not by pleading guilty to them, you're giving up your right to a trial by jury?
Yeah.
Has anybody forced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated. Good luck to you, Mr. Katz.
Okay. All right, next we got 20 through 22, Mr. Perkins.
Yes, Your Honor, positions 21 through 22 are one person. And I also believe that Jules, his mother is in the Zoom call, Jewel Ross, if she can just be given a moment to speak on behalf of the defendant.
Okay, so this is going to be an arraignment and a bond hearing? Is that right, Ms. Helen?
No, Your Honor, I've waived arraignment on all three positions. I only requested a bond hearing on position 21.
Okay.
And I submitted that to Ms. Grace. I do believe she received it.
So does he have a bond currently set on, I would imagine he does, on position 21?
2,500 cash, Your Honor.
And can you tell me what the bonds are on 20 and 22?
Yes, Your Honor, 2,500 signature for each. 2,500 signature bond on position 20, 2,500 signature bond on position 22.
All right. Who's representing from the state?
It'll be my colleague, Your Honor, and me.
I apologize. I didn't hear the position on this.
Okay, so we're on positions 20, 21, and 22.
Yes, and that is all the same individual. Okay, give me one
Yes,
second, Your Honor.
and Ms. Helen wants a bond hearing just on position 21.
Okay, on 21.
Yes, and there's a $2,500 cash bond set at the present time.
Right, Your Honor. So basically, it looks like, and again, I think these incidents were all back to back. And so on 6/6, 6/10, and 6/11, this defendant battered the same victim, which was his sister, Miss Yasmin Persons.
I'm sorry, Judge. Two positions are from 2019. I just gotta, I gotta make that clear. These are not back to back.
Let me check on that, Your Honor. Because that's not.
Okay. The calendar says on position 20, it was in June 6th of 2019, and position 22 says June 9th of 2019. And the position that we're here on is.
Okay, so there were three, so two were in the same year and one was in, okay, got it.
Right, okay.
All right, give me 1 second. And this one was a 6/6. Okay, so on this one, Your Honor, and I think because we've got, like I said, 20 through 22, all with the same individual. On 21, there was no offer, but the bond is $2,500. This, like we said, the defendant has a history of offending against this victim. And even if it wasn't back to back, even if it's 2 times in 1 year and another time in 2022, he still has a history with this particular individual. And let's see, he's got 8 cycles in Georgia from 2004 to 22. 2015, simple battery family violence. 2019, assault family violence. Your Honor, I think that $2,500 is appropriate. He obviously does not heed to the court. He obviously does not listen to instruction. And so we are asking that the $25,000 cash bond stay in place. Nothing further from the state.
2,500.
Correct.
Okay. Ms. Helen?
Yes, Your Honor. Mr. Persons is 34 years old. He currently is a lifetime resident of, or a lifetime resident or a current resident of Fulton County. So he does have current Fulton County ties. His mother is on the Zoom call, so he does have family and community ties. Miss Jewel Ross, I do ask that she be given an opportunity to speak on behalf of Mr. Persons. When I spoke to Mr. Persons, as I spoke earlier, position 20 is from June 6, 2019. That mentions Yasmin Person, who is his sister. Position 22 is June 9th. That's about 3 days later, 2019, with the same individual, Yasmin Persons. When I spoke to Mr. Rashad, Miss Yasmin does suffer from mental health disorders, which causes her to become violent towards Mr. Persons and then call the police for these incidences and report that Mr. Persons is the one assaulting her. I spoke to Mr. Rashad. He is currently living with her as her live-in caregiver and has been doing so. That address is 3350 Mount Gilead Road, Southwest Apartment J, 85 Atlanta, Georgia, 30311. He has been living there, helping her, again, since 2019. He has been living with her. She does not work. He works. He provides and pays for all of those bills that come through that housing. And so, Judge, we are asking for this to be a signature bond for Mr. Rashad Persons. Again, I heard his history, but this is not a violent offender of the community. He has strong community ties. His mother is here to speak on his behalf. Mr. Persons is trying to help his own family. It's unfortunate they are resulting in these cases. But Mr. Persons is not a violent offender. He does not have the history to reflect that. These incidences are unfortunately with individuals who are suffering from some type of mental health disorder, Judge. So we are asking, and again, those 2 other cases, he was granted a signature bond, a $2,500 signature bond, and a simple battery family violence that she was involved in. And then the other position, 3 days before, he was also granted a $2,500 signature bond with, again, Yasmin Person mentioned as the alleged accuser, Judge. I would like for him to be given a signature bond so that he has an opportunity to fight all three of these cases from outside of Rice Street Jail, Your Honor. And if you do feel that he is ineligible for that signature bond, I am asking for a bond modification. He cannot afford the $2,500 cash. That is essentially why he is still there. We are asking for a bond modification from cash to a $1,000 surety, Your Honor.
Your Honor, go ahead.
Hold on one second, Ms. Bacchus. Let me just address what Ms. Helen said. And I am going to give Ms. Ross the opportunity to speak at some point. But again, Ms. Helen, you know, my biggest pet peeve is that when you don't follow a previous order, and the previous orders both said no further contact with the alleged victim on both of those orders. So he shouldn't, and I understand people as far as their families go and things like that, but there's a process and there's a way to do things. That if you want a bond modification to where you can have contact with an alleged victim, then you need to go through the process to get that done, as opposed to violating the bond orders and then possibly being right back in the same situation that you were in, but for if you had stayed away or if you had done something differently, you wouldn't be in violation of the order. So that's what concerns me the most in these types of cases. Just so you know that. Ms. Bacchus, I'll go back to you.
Yeah, I just briefly wanted to say, Your Honor, again, we feel that the $2,500 is appropriate. If he is the sole worker in the family, he's supposed to be the caretaker. According to the police reports from one of the incidents, he's not caretaking very well. The house is in terrible conditions, almost hoarder-like conditions. And like I said, he's done this multiple times. He is 6'5", 275 pounds. This is a woman, despite the fact that it's his sister. He has been violent numerous times and he's a very big man. And so we feel as though he has not learned. And so that needs to stay in place.
And Your Honor,
from the state.
Mr. Persons also has defensive bite marks on his left arm, has defensive wounds on his hands. Again, as a family, and I do hear you, Judge, about violating that order, he was taking care of her. She was not working. I do not believe she is currently working, Judge. So I do hear what the state is saying, but Your Honor, Mr. Rashad Persons is a big guy and he has his own defensive wounds. Your Honor, trying to prevent himself from being assaulted or hurt. So Judge, we are asking for that signature bond. If not that signature bond, we are asking for that $2,500 cash be modified.
Ms. Ross, if you would like to address the court, I'll need for you to unmute yourself and I'm going to have to swear you in, okay? So can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
Your Honor, this is a very difficult thing for me. You know, it's my children.
Yes, ma'am.
But Rashad is not a violent person. He really is a gentle lamb, really. You know, he's a big man, but he's a caring, loving person. And it's just unfortunate that, you know, he was trying to stay there you know, I felt that it could have been a good situation because, you know, I know that my daughter needs the help. But it just hasn't worked. It just hasn't worked out. It hasn't worked out. Rashad he's not a menace. He's not, you know, he's trying to work. He's, you know, has a job and, you know, housing today. I don't know if you know or read about how the cost of the housing has gone up for renters and owners to, you know, to a point that people can't even find a place to live, you know, but, you know, I'm working to try and help him get another place to stay because living with, you know, them living together and him trying to help her is just, it just hasn't worked. And it's unfortunate because she needs help. She needs help. And I, as the mother, have done all that I can do, all that I know to do, you know, to get her the help that she needs. And, you know, now he's in a position as well that needs help with housing. And, you know, I don't know if he's even lost his job as a result of this. So it's a very difficult situation for me as the mother in this, but you know, I just pray that the court will have leniency and give him an opportunity to be able to get out and to, you know, rebuild his life at this point. You know, I mean, of course, he can't live there with her. But to my knowledge, there never was a situation where he was told that he couldn't be there because they were living there together and he was trying to help her. So.
All right. When you say there, is this the 3350 Mount Gilead Road address?
Yes.
Okay. And is that different than your address?
Yes, it is.
Okay. All right. Thank you, ma'am.
All right. Thank you.
Anything further, Ms. Bacchus, Ms. Helen?
Your
No,
Honor,
Your Honor.
I've just heard this multiple times today that defendants had no idea about no contact orders and such. And the reality is that would mean that no attorney is telling their client what is happening. And I refuse to believe that with 2 of these prior cases that he had no idea that there was a no contact order in place. Nothing further from the state, Your Honor.
And Judge, I understand ASG said that she can't believe it, but I spoke to Mr. Rashad, and that's the position that we're in. You have heard from Mom. Again, I would like for him to go to another address, again, to stay away from this alleged accuser and not have any other reoccurrences. And again, he doesn't have that history to be a violent offender. So Judge, yes, we're asking for that signature bond. And if not, we're asking for that modification, Your Honor.
Your Honor, if I may add one other thing.
Yes, ma'am.
I don't even know about the previous case per se, but I do know of when the police came, they have come out there because Yasmin has called the police and they have come. And I do know I even spoke with the police myself one of the times when the police came. I can't remember if it was this prior incident date. I don't remember the date, but I will say when the police came, I spoke with them and there was nothing said about him not being able to live there.
All right. So I don't know how other judges do it, but I know that when I issue a no contact, I make it clear that there's not to be any contact. So I would think that most other judges are going to do that also. And the fact is that in the other 2 cases, there was a no further contact issued. And just so you both know, and you both heard it from me, both Ms. Ross and Mr. Persons, no contact, and regardless of what your situation is, no contact means absolutely no contact. No personal contact, no phone contact, no email contact, no social media contact, no contact whatsoever. So if there was a no contact order put in place, there certainly should not have been living together. And I understand all the other family issues or personal issues that can cause a problem for. But that's the ruling of a court. So you just can't violate it, as I was saying before. You'd have to go and modify it. And I understand what you're saying, Ms. Ross, that he's probably trying to help his sister, but he's not helping his sister, and he's just hurting himself. So I am inclined to reduce the bond from a cash bond, but it's not going to be a signature bond. It's going to be a $2,000 good bond. No further contact, and as I've explained what no further contact means with Yasmin Persons, stay away from the 3350 Mount Gilead Road address, apartment J85, I believe. he can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, no alcohol or weapons while out on bond.
Mr. Persons, did you hear and understand what just happened?
Yes, on the,
Oh, Mr. Persons, I'll answer any questions for you. I'll call you. I just want to make sure you understood that he modified the bond, so it's not cash, okay?
yes, thank
Okay,
you.
so you can explain, you can call him and explain that to him, Ms. Helen, and emphasize the no contact and that he can go back there on one occasion with law enforcement if he makes bond.
Yes, Your Honor.
Okay, good luck to you, Ms. Ross and Mr. Persons.
Thank you.
All right, next we got number 4, Mr. Evans.
What
And while we're-
position is this, Your Honor?
While we're waiting for that to happen, let me just see where we have this non-jail plea calendar at 11 o'clock with Mr. Karam. Who is the Forsyth? You can go ahead and sit. I just want to tie up some loose ends here. It's my understanding that that this is not going to be a plea today. What are we doing with this case?
That's correct, Your Honor. It's not going to be able to be resolved today, so it needs to be reset further notice to the division judge.
Okay.
Perfect. Thank you, Judge. Good to see you again.
Okay. Yeah. Good to see you. Okay. So, and has he already been arraigned?
Yes, Judge.
Okay. So we'll return this to the division judge for jury trial.
All right.
Okay.
Thank you, Judge.
You're welcome.
Excused.
All right. Anything further?
No, I was just asking if we could both be excused.
Oh, yes. Have a good day. All right. Be safe. Okay. And this is Mr. Evans. Is that right?
Yes.
Good morning, Mr. Evans. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir, I agree.
Okay, thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, Mr. Evans. Mr. Finley, this is going to be a negotiated plea.
That's correct, Judge.
Okay, Ms. King.
Yes, Your Honor, the offer is 12 months to serve 9 days, credit for time served 9 days with the balance probated, 4 theft classes, and a stay away from the incident location, which is 3599 MLK Junior Drive Southwest, which is a Dollar Tree.
Do you object to termination once he completes the theft class?
No, Your Honor, no objection.
Okay, anything further, Mr. Finley?
Nothing further, Judge.
All right. Mr. Evans, it's my understanding that in case 22 CR 003834C, you wish to plead guilty to 1 count of theft by taking and 3 counts of theft by shoplifting. Is that correct?
That's correct, sir.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Very satisfied, sir.
You understand that you have a right to a trial by jury on these charges, and not by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir, I agree to waive.
Has anyone forced or coerced you to plead guilty?
No, sir.
All right, I will accept your guilty pleas, Mr. Evans. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And as soon as you complete the theft class, the probation will terminate, okay?
Thank you, sir.
You're welcome. Good luck to you, Mr. Evans.
Thank you, Your Honor. All right, next we got number 15, Mr. Love.
Is that 15?
Yes, sir.
Okay.
And this would be an arraignment, Judge.
Okay. Good morning, Mr. Lowe. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Can you hear me, Mr. Lowe?
Yes, I can hear you.
Okay, we're doing this by video. Is that all right with you?
Yes, sir.
All right, can you raise your right hand for me, Mr. Lowe? Do you swear or affirm the testimony that you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, sir. Mr. Lowe, you've been charged in case 22 CR 003757J with battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you ready for the reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead to this charge, Mr. Lowe? Guilty or not guilty?
Not guilty.
Mr. Finley?
Sorry, Judge, you cut off for a second. Can you say one more time?
I believe that he said, I asked him the question, do you plead guilty or not guilty? And what did you say, Mr. Lowe?
Not guilty.
Not guilty? Okay, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. All right, good luck to you, sir.
All right, go on to the next floor now. South End, take over.
Okay.
Good morning, everybody.
Good morning, Officer Melton. How are you?
Well, coming
Good.
up is position 7, Ms. Grisham.
And this will be a negotiated plea, Judge Morrow.
Okay. Good morning, Ms. Grisham. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
I do.
Okay, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Ms. King, you can put your hand down, Ms. Grisham.
Yes, Your Honor. The negotiated terms are as follows: 12 months to serve 12 days, credit for time served 12 days with the balance probated, a theft class, and no further contact with the victim, Muhammad Amin, MUHAMMAD AMIN.
Mr. Finley?
Yes, Judge, that is our understanding of the offer, of which we do agree. We would just ask that once Ms. Grissom does complete that theft class, that the balance of her probation could be terminated.
Any objection?
No objection, Your Honor.
Ms. Grisham, it's my understanding that in case 22 CR 003750C, you wish to plead guilty to theft by taking, is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
I'm not.
You've been represented by counsel. Are you satisfied with his representation?
I am.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I understand.
Has anyone forced you to plead guilty?
No.
I'll accept your guilty plea as negotiated, Ms. Grissom. I'm going to waive your probation fees while you're on probation, and when you complete the terms of the probation, it will terminate, okay?
Okay, thank you.
All right, you have a good day, ma'am.
Thank you.
Next, we have position number 8, Ms. Peak.
And this will be a negotiated plea as well, Judge.
Good morning, Ms. Heath. I'm Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, ma'am? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Ms. King?
Yes, Your Honor. The negotiated terms are as follows. For simple assault, it's 12 months to serve 30 days, credit for time served 15 days with the balance probated, with 8 weeks of anger management and a stay away from 185 Central Avenue unless she has business in that building. For obstruction is 12 months probation to be served concurrent, and for criminal trespass is 12 months probation to be served concurrent.
Mr. Finley?
Yes, Judge, we would just ask, that is our understanding of the offer, of which we do agree, and would just ask that once she completes that anger management, that the balance of her probation could be terminated, but if you're not inclined, then non-reporting, Judge.
I will, is there any objection to non-reporting?
No objection, Your Honor.
Okay. Excuse me. Ms. Heath, it's my understanding that in case 22 CR 003824C, you wish to plead guilty to simple assault, obstruction of a law enforcement officer, and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated. Ms. Heath, I'm going to waive the fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, it will go to a non-reporting status, okay?
Thank you, sir.
All right, good luck to you, ma'am.
Yes, sir.
Next, we have position 25, Ms. Wilder.
Good morning, Ms. Wilder. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. This is a non-negotiated plea, Ms. Helen.
Yes, Your Honor.
May I get her history, please?
Your Honor, as a new ASG, I have to ask, does the history need to come from pretrial? Or if we have it in front of us and they don't have it, are we?
Quite often, Ms. Bacchus, Ms. Heller will request that it come from pretrial.
Okay.
But if you have anything that you would like to emphasize or supplement, I'm always happy to hear.
Perfect, thank you.
All right.
Last arrest, September of 2021, criminal trespass, willful obstruction of law enforcement officers. That was a conviction. Record indicates an open probation for willful obstruction of law enforcement officers by force of violence or threat. Case number 21 SC 179560, sentenced February of 2022, 2 years probation. 3 violations of probation, 1 failure to appear within the past 10 years. A 2018 simple battery conviction, misdemeanor, 2020 simple battery, and a 2018 disorderly conduct. Nothing further to add.
Okay, Ms. Bacchus.
Your Honor, we show that there are 17 cycles from 2007 to 2022. And there are additional charges, which I'll go into after I talk about the facts. Officers responded to a hang-up call at a Stop and Shop on Allison Court Southwest in Fulton County. Upon arrival, officers saw the defendant, and in speaking to the store clerks, they expressed that they did not want the defendant at the store just because of her erratic behavior. The clerks gave her a verbal trespass warning and told her to vacate the premises, which she refused. And in the process of detaining the defendant, she began to resist arrest. And because she was trying to restrain the officer, her and the officer fell to the ground. And eventually they were able to get her restrained and into cuffs and into custody. Your Honor, we offered 12 months, 90 days to serve, credit for time served 13 days as of 6/24, and then balance suspended. Stay away from the incident location, no alcohol, drugs, or weapon. Your Honor, this defendant, like I said, has 17 cycles from 2007 to 2022. We've got a 2018 simple battery, 2018 disorderly conduct, 2018 possession of cocaine, for which she got 3 years probation, a 2019 probation violation, 2020 probation violation, 2020 simple battery, 2020 theft, which is an open case, another 2020 probation violation, 2021 willful obstruction, 2022 willful obstruction, for which she got 2 years probation. And then we've got our case, right? So the defendant, like I said, she has a pretty lengthy history just over the last 3 or 4 years. She's well aware of her behavior and the consequences, and she continues to engage in similar conduct despite the numerous chances and grace given by the court. She has a serious risk of reoffense as she was placed on probation. Like I said, multiple times that didn't work. Probation violations, right? It doesn't work, right? And so, Your Honor, we're asking that this jail time, the state doesn't feel as though this jail time is excessive. And once she completes the jail time, then her balance is suspended. And we feel that that is the appropriate recommendation. Nothing further from the state.
Yes, Your Honor, this is a non-negotiated plea. We are asking for time served, balance suspended. I do hear her history. When I went down and spoke to Ms. Wilder, she is residentially challenged, has been so for several years. That is the basis for those criminal trespass. So as we talk about this criminal trespass that we have here, she was warned. And as she was walking past the, I think it's a gas station stop and shop, she came right into that officer that asked her not to come back that first time, Judge. So she didn't offer violence. She wasn't offering violence to people there. So we are asking for time served, or the 16 days that she's done at the South Annex jail to be considered time served with the balance suspended. Again, a stay away, adhering to the stay away location, Judge. 12 months probation. I want Ms. Wilder to be successful. I want to ask for time served, balance suspended. Again, because she is residentially challenged, she has no income, she cannot be successful paying probation, Judge. So we are asking for time served, balance suspended with the condition of staying away from the Stop and Shop. No drugs, weapons, or alcohol.
Your Honor, the state offered balance suspended, and we are not opposed to no probation fees, but as I stated, based on the police report, there was actually violence. She resisted arrest and the officer fell to the ground. We could have charged her with resisting arrest. We could have charged her with simple battery. We did not. She has been charged with the criminal trespass, but for the defense to make the argument that there was no violence in the situation, that's not factual.
Hey, Judge, she didn't say she pushed the officer.
She was trying to restrain the officer by his own account.
So, Your Honor, I don't hear that Ms. Wilder, and she wasn't even charged for the obstruction. She was charged with the criminal trespass. So based off what she was charged with, we are asking for time served, balance suspended.
Okay, anything further, counsel?
Nothing from the state, Your Honor.
No, Your Honor.
All right, Ms. Wilder, it's my understanding that in case 22 CR 003730J, you wish to plead guilty to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea, Ms. Wilder. The sentence is going to be 12 months to serve 17 days, credit for time served. 12 months to serve 34 days, credit for time served 17 days. Balance suspended, stay away from that Stop and Shop. You understand you can't go back there, ma'am, right?
Yes. Yes.
All right, so don't be on that property, otherwise you're going to be right back here.
Right.
All right,
Thank you.
good luck to you, Ms. Wilder.
Thank you, Ms. Wilder.
Thank you.
Next, we have position 18, Ms. Minor.
Judge, can I have a breakout room for Ms. Minor?
Okay, and I had on my calendar that Ms. Minor was reset until
Well,
July.
That's what I was gonna have
Yeah.
a breakout room at.
Okay, so are we gonna reset her for July 5th?
Yes, Your Honor.
Okay, all right, so she'll be back on the July, we don't need her today, Officer Milton. She's gonna be reset to July 5th.
My apologies, Your Honor. What position was that?
No problem, it's position 18.
Okay, perfect. That's what I had. Thank
Okay.
you.
Okay, all right. You understand, Ms. Minor?
I'm set for July 5th.
Yes.
Okay.
All right, thank you. Next, we have position 26, Ms. Williams. Ladies, no talking.
And what's not negotiated here?
Judge, what's not negotiated is that I have her for 14 days of confinement, the recommendation, or I guess that is, but the probation, Judge, we're asking for time served, balance suspended. And after she pays the restitution, if it can be balance suspended, and of course, to stay away from the location.
Has she been in for 15 days is what the calendar says?
I have 14. I'll double check Odyssey.
Let me look at that quickly.
Okay. Did you mean for this to be a time served plea, Ms. Bacchus?
So let me, I put 30, serve 30, credit for time served 15 days. Service. Yes.
Okay, so I do have 15. I just wanted to make
Okay.
sure.
So it's negotiated.
Yes, Your Honor.
Okay, and Ms. Williams, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
No. Do you want to do it here?
Yes.
Speak up so you can hear you.
Yes.
Okay, thank you, Ms. Williams. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you, ma'am. Ms. Bacchus?
Your Honor, the state is recommending 12 months, like I said, 30 days, credit for time served 15 days, balance. It actually looks like we have balance probated here. But I believe it should be, I believe that's a typo. It should be balance suspended and stay away from the incident location and restitution for the services, the $232 that she did not pay to the location.
Right, and I'm just gonna chime in briefly, Your Honor, it will be balance probated.
Okay.
After the restitution is paid, the probation can terminate.
Okay.
Thank you, Ian.
And that's what I thought you meant, Ms. Bacchus. So, Ms. Helen, anything further?
No, Your Honor. I just want to make sure, Ms. Williams, you understand that you'll be on probation until you pay the restitution fully.
Why? Why probation?
Because you're gonna have to pay $232 in restitution. So we're gonna put you on probation so you can pay that. And as soon as you pay it, then you'll be done and you won't be on probation any longer. You understand?
Yes.
Okay. Do you have any other questions of Ms. Helen before we go forward? Ms. Williams?
I can also call Ms. Williams at the jail too, if you have any questions, Ms. Williams.
No, I don't.
Okay. Ms. Williams, it's my understanding that in case 22 CR 003831G, you wish to plead guilty to theft of service. Is that correct?
Yes.
Under the influence of any drugs or alcohol this morning?
No.
You've been represented by Ms. Helen. Are you happy with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Oh.
You don't want a jury trial, do you?
No.
Okay. Has anybody forced you or coerced you to plead guilty?
No.
All right, I'll accept your guilty plea as negotiated, Ms. Williams. Once you pay back the $232, the probation is going to terminate, okay? So the quicker you can get that done, the quicker you won't be on probation. And if it does take you more than a month, I'm going to waive the probation fees for you so that you can get and stay on your feet, okay?
Okay.
All right. Good luck to you, Ms. Williams.
Thank you.
You're welcome.
All right, Your Honor. Thank you, everybody. Have a good day.
Thanks,
All
Officer Milton.
All right. Am I going to see you this afternoon?
No, sir. I'm sorry.
All right. Have a good day.
Bye.
Who do we have?
We have position number 5, Mr. Farley.
Good morning, Mr. Farley. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Was that a yes? I'm sorry.
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Farley? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Farley. I've got Mr. Finley that this is a negotiated plea. Is that right?
That's correct, Judge.
Ms. King?
Yes, Your Honor. The negotiated terms are as follows. For terroristic threats, 12 months to serve 15 days, credit for time served 15 days with the balance probated, 8-week anger management class, no further contact with Tiana Horton, TYANNA HORTON, and stay away from incident location 7030 Preserve Pass in Fairborn, Georgia.
Mr. Finley?
Yes, Judge. That was our understanding of the offer. We agreed to the time served. Mr. Farley also did want me to point out that he did get an FTA, but it was due to the fact that he was incarcerated. So he wanted to make sure that I pointed that out. But we do agree to the 8 weeks anger management. And we would just ask that once he does complete the anger management, the balance of his probation could either be terminated, but if you're not inclined, Judge, then be non-reporting.
Any objection to non-reporting, Ms. King?
No objection to non-reporting, Your Honor.
Mr. Finley, your client has his hand up.
Yes, Mr. Farley?
I was just recently in another county. I've been locked up 8 months.
Okay. Mr. Farley, it's my understanding that in case 19 CR 006994J, you wish to plead guilty to terroristic threats. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated. Mr. Farley, I'm going to waive the probation fees while you're on probation to help you get and stay on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status, okay?
Yes, sir.
All right. Good luck to you, sir.
Thank you. I have one more question. So I got time served, right?
Yes, you did.
Okay, thank you. I appreciate it.
You're welcome.
Have a great day.
You too. Okay, let's see. Do we still have someone from the jail on the line?
Yeah, I'm here.
Okay, so we still have position number 6.
Yeah, I'm on my way to the 3rd floor now.
Oh, okay, all right. So we'll wait to hear back from you.
Okay.
All right. Let's see, 6.
Position 10 as well, Your Honor.
Okay. And what are we going to? Did you all get the add-on calendar or not?
We received it, Your Honor, and I have communicated an offer for position 2. I think PD Finley is talking to that person right now, potentially.
Okay.
Position 1, I'm not sure why she's on the calendar. She's been arraigned and she's been on the SAP calendar about 10 times now. I think she just needs to be reset further notice for her division judge, but.
And yes, I'm on the phone actually with Officer Norris right now about Mr. Hood, and he was unaware about the add-on calendar as well. So he's trying to figure out if he can get him.
Okay. And who is representing Whitney Craig, position 1 on the add-on calendar?
I can speak to Ms. Craig if she is at the South Annex Jail, but.
Did you hear what Mr. Walker said, Ms. Helen, regarding that she should be
Oh,
reset?
yes,
further
Your Honor, I
notice?
apologize. I cut off on that message. I apologize, yeah.
That's fine.
Hey, Your Honor.
Yes.
Can you hear me?
Yes.
Yeah, because I'm actually in the middle. Can you sit down for me, please? Sit down. He sat on the sandwich. Do we need to get Hood now? Because I'm in the middle of doing misdemeanor. I thought I didn't get any add-on calendar, so I went straight to my next calendar. I thought we were done with the whole SAP.
Okay. Let's see. I don't want him, if we can, is this?
It's a time server
Time
offer.
served?
I have no idea if he's going to take it or not.
Officer Norris, I don't want him sitting, and if you can get Mr. Hood for me, I appreciate that, because if he's gonna take a time served plea, he'll be getting, well, it'll be time served on this. I don't know if he has anything else that's holding him, but if he doesn't, he could be released from the jail today. So are you able to do that, or am I gonna have to reset this?
Just give me a few minutes, because I'm
Okay.
gonna get these guys straight over here with misdemeanor. Give me a few minutes. I'll be right.
All right, okay, I appreciate it.
All right.
Yes, so in position number one, we're going to reset further notice.
That's correct. It looks like she was arraigned back in March. I'm not sure why she's been on our calendar so many times.
Okay, thank you. All right, so we'll be in recess until the jail comes back. While we're waiting, so as not to, so that we can move this on, if you all want to go over the calendar, Ms. Grace is ready for that. Is that okay with everyone?
Yes, Your Honor, that will be great.
That works,
Okay.
Judge.
All right.
Position number 1, the plea. Position number 2 is reset further notice and arraign. Position number 3, reset jail jury further notice and arraign. Position number 4 was a plea. Position number 5 was a plea. We're holding on position number 6. Position 7 and 8 were pleas. Position 9 was reset jail jury and arraign. We're holding on position 10. Position 11 was a plea. Position 12 is gonna be, was arraigned in jail jury. Position 13 and 14 was pleas. Position 15 was arraigned jail jury. Position 16 was a plea. Position 17, jail jury arraigned. Position 18, reset 7/5/22, SAP. Position 19 was arraigned in a bond modification. Position 20 was reset jail jury. Position 21, 22, 23, reset jail jury. Position 23, reset 7/5/22, SAP. Position 24 was a bond modification, arraigned, reset jail jury. Position 25 and 26 were pleas. Position 27 and 28 were pleas. On the add-on, position 1, reset further notice. We're holding on position 2. Position 3, reset further notice. And on the plea calendar, reset further notice.
Okay. Who do we have at 3 South?
Yeah, position number 6, Mr. Foster.
This is a negotiated plea, Mr. Finley.
That's correct, Judge.
Good afternoon, Mr. Foster. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Can you hear me?
Yes, I can.
Okay, we're doing this by video. Is that okay with you?
Yes.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Foster. Ms. King?
Yes, Your Honor. The negotiated terms are as follows: for public indecency, 12 months to serve 12 days, credit for time served 12 days, a sexual deviancy class, MHET, and a stay away from the incident location. In the incident report, it listed as the park across from 3107 Peachtree Road. I did a Google search, but I was not able to come across the name of that park. So I'll defer to Your Honor how to word it in the conditions.
Okay. Mr. Finley?
Yes, Judge. That is our understanding of the offer, of which we do agree. And we would just ask that once he does complete that class and the MHET, that the balance of his probation could be terminated. But if you're not, but if you're not inclined, Judge, then non-reporting status.
Non-reporting, unless there's an objection from Ms. King.
No objection to non-reporting.
Okay. And where was the park located, Ms. King? It doesn't have a name?
It wasn't in the incident report, and when I did a Google search, I was not able to come across one. It just says the park across from 3107 Peachtree Road.
Okay, 3107 Peachtree Road. And that's how we'll indicate the park across from 3107 Peachtree Road.
Thank you, Your Honor.
All right, Mr. Foster, it's my understanding that in case 22 CR 003765F, you wish to plead guilty to one misdemeanor offense. Is that correct?
No contest.
Okay. Well, your counsel has not asked for no contest. Did you, Mr. Finley?
I did not. Do you want me to ask for a NOLO on your behalf, Mr. Foster?
You saying
The state would object to a NOLO plea, Your Honor, due to the defendant's criminal history. He has.
Oh, hold on, Ms. King. I just want to make sure. Maybe he didn't say that. So,
Yeah.
Mr. Foster, it's my understanding that, what was negotiated was a guilty plea.
Do you want me to ask for a NOLO on your behalf, Mr. Foster? No.
I'll take the one that you're saying.
Sorry, Mr. Foster, I'm not understanding.
Um,
Do you want me to ask for a NOLO contingere on your behalf?
let's ask for anyone to speak for me. I saw you yesterday.
We spoke yesterday about you
Yeah.
being guilty,
So,
yes, sir.
so what's going on? So what was told yesterday? I just go with that.
Well, we are moving forward with a guilty plea, but just trying to make sure, do you want me to ask for NOLO on your behalf? If not, we'll move forward with the guilty plea. Maybe I should.
You might need to call him, Mr.
Yeah,
Finley.
I'm gonna call him.
And just so I can, before you do that,
Yes, sir.
Ms. King, can you give me the, what you have as far as the history goes?
Yes, Your Honor. The defendant has a prostitution conviction out of Florida from 2010. He also has an exposure of sexual organs arrest out of Florida as well. And that was from last year, 2021, Your Honor. Due to those reasons, a NOLO is not appropriate in this case.
Okay, and I agree with her, Mr. Finley, but if you want to discuss that with Mr. Foster, I'm happy to give you that opportunity.
If I could just briefly speak with him, and I'll obviously relay what
Okay.
we both said.
All right. So do you
If I
have?
could be in a breakout room possible, or I can call, whatever.
That's
easier.
fine. I think that we're only at 3 South, so can we put them into a breakout room? Is that possible? Ms. Champion?
Yes, sir.
Thank you. All right, Judge. Mr. Foster is ready to move forward with the guilty plea.
Okay. Give me 1 second. Thank you. Okay, Mr. Foster, it's my understanding in case 22 CR 003765F, you wish to plead guilty to 1 misdemeanor offense. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this afternoon?
No.
You've been represented by counsel. Are you satisfied with his representation? Are you happy with what Mr. Finley's done for you, Mr. Foster?
Okay, sure.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Okay.
Is that a yes?
Yes, the charge, to me, wasn't that,
Mr. Foster, sir, I'd recommend you not say anything related to the facts of your case. If you could just answer yes or no to the judge, please.
okay.
Thank you, sir.
Okay, so you don't want a jury trial, do you, Mr. Foster? No?
You said I was leaving today, so I wouldn't.
Okay, you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury. You understand that?
So he would have to go?
No, Mr. Foster, the judge is asking you, like I asked you yesterday, that but because of your guilty plea, you're giving up your right to a trial, so you're not going to have a trial. You understand that?
That's what I want. That's what we talked about. Leave
Okay.
today and not have to worry about trial because the fact that I pleaded guilty to the charge. Already, you said time served.
Okay, so you don't want a trial, is that right?
You can answer yes or no, sir.
Yes, I don't.
Okay, has anybody forced you to plead guilty?
I never do drug use for that situation. No.
So that's a yes or no also. Has anybody forced you to plead guilty?
I never do drug use, so no. I'm never forced to do anything.
Okay. I will accept the plea as negotiated. I'm going to waive the probation fees for you while you're on probation to help you stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay? Good luck to you, Mr. Foster.
Thank you.
You're welcome.
Thank you, Judge.
All right, got Mr. Hudson here. Number 10, Mr. Hudson.
I will need to speak with him as well.
Okay. So if we can put Mr. Hudson and Mr. Finland into a breakout room. All right, Mr. Finley, where are we?
Yes, sir. It's going to be a negotiated plea for Mr. Hood.
Okay. Good afternoon, Mr. Hudson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Mr. Hudson. Ms. King?
It's my
Oh,
case, Your Honor.
Mr. Walker?
Yeah, it's going to be time served. We could just say 5 days, balance is suspended with the stay away condition at 7660 North Point, located in Alpharetta, Georgia.
Is that the mall?
I believe so.
Okay. Mr. Finley?
Yes, Judge, that is our understanding of the offer, of which we do agree and stipulate to the factual basis, ID and venue.
Mr. Hudson, it's my understanding that in case 19 CR 0064001A, you wish to plead guilty to theft by shoplifting. Is that correct? Can you hear me, Mr. Hudson?
Yes.
All right. Do you wish to plead guilty to theft by shoplifting?
Yes. Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anybody forced you to plead guilty?
No.
I'll accept your guilty plea as negotiated, Mr. Hudson. Good luck to you, sir.
Thank you.
He said 5, credit for 5 and 5. Okay. Courtroom. So are we done at 3 South now?
Yes, sir.
All right. Have a good afternoon. And we've got in the courtroom 2, is this Mr. Hood?
Yes, sir.
Good afternoon, Mr. Hood. Are you gonna, so what's going on? Is this your client, Mr. Finley?
Wait, that was just Mr. Hood. Okay.
Right.
Okay, who do we have in courtroom 2?
That's Mr. Hood, Your Honor. He answered you.
Okay, so yeah, that was,
Oh,
Mr. Hudson was position number 10. Y'all are trying to confuse me. I've been sitting here for too long.
And I'm confused now too.
I am too.
I'm like, why didn't y'all stop me in the middle of my plea?
I thought we were on Hood.
Okay. All right, so that's,
So what happened? You already did Mr. Hood?
no, well, Mr. Hood got a better deal than, no, Mr. Hudson got a better deal. Mr. Hudson apparently got Mr. Hood's deal, but it all worked out in the wash. All right, so this is Mr. Hood, position number 2 on the add-on calendar. What are we doing with Mr. Hood?
This is, I'm gonna need to speak. with him.
Okay, so
Yeah.
this is a criminal trespass charge.
Yes.
All right, so can we put Mr. Finley and courtroom 2 into a breakout room?
Yeah, so
Okay, Mr. Finley,
Yes, sir. Yeah, we're good to go, Judge.
say it again.
We're good to go, Judge. That's gonna be a negotiated plea.
Okay. Mr. Hood, you've been charged. Good afternoon, Mr. Hood. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Mr. Hood?
Oh, yes, sir.
Okay, and you agree to have this heard by video?
Yes, sir.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Hood. Mr. Walker?
Yes, time served, 5 days. Stay away from 7660 North Point Parkway located in Alpharetta, Georgia.
Mr. Finley?
Yes, Judge, that is our understanding of the offer, of which we do agree, and additionally stipulate the factual basis, ID, and venue.
Okay. Mr. Hood, it's my understanding that in case 21 CR 005580F, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
All right, I'll accept your plea as negotiated, Mr. Hood. Good luck to you, sir.
Yes, sir.
Okay, and with that, I think that completes the 9 o'clock state all-purpose calendar. Anyone have any questions or concerns?
We're sending all paperwork to Grace.
Say it again?
Are we sending all of our paperwork to Grace?
Yes, Melissa Grace.
Okay.
And if you all can get that in as soon as you can, that'd be appreciated. Thank you, courtroom 2. I'll see you in a little. I'll see you in a little while.
Was there, I'm sorry, hold on. Was there somebody else?
No, I think this is our last person, right? Right? Did we get everybody? Somebody speak up if we didn't. Okay. All right. I think we're done.
Okay, thank you.
All right. See you in a little while.
Thank you, Your Honor.
Later.
All right.
Thank you, Judge.
Y'all have a good day. I'll see you next week.
Thank you, Judge.